Yes, Mr.
Okay, I mentioned this matter yesterday, my lord, for listing today, my lord. But
There
it
was some
not been listed.
typographical. For what was it?
For correction of typographical
Ani
mistake,
diya
my
nahi.
lord.
Kya aana hai? Huh?
Yes.
By the way, thora hide khali nahi diya.
May his lordship with due consent from the other side.
You had made a mention, submitted a submitted.
For-
Item 4.
When?
I will take next week. Next week.
Next week. As prayed for by Mr. As prayed for on behalf of Mr. R. Mujumdar, learned counsel appearing for the petition and not objected to by Mr. K. Gugui, CGC appearing for the respondents. The matter stands adjourned. Puts up registry to list this matter again on 8/8/2024.
Okay.
Mr. Gugui, that
Lordship.
matter Abdul Barak Mia,
Lordship.
I could not complete my notes.
Lordship.
We'll have it on Thursday. I'll pass the orders on
Lordship.
Thursday.
Lordship.
Yes, Lordship. I am praying for listing the matter WBC Lordship 2969.
You will have to mention before the senior court. My Lord Justice made his court. Okay. Yes, Mr.
Please, Your Lordship. Lordship, I beg to mention item number 27.
Why?
On Thursday, Lordship.
Why?
Oh, Lordship, my senior is not available today.
Why?
Yes, he is out of station.
Okay, you be here. We'll not pass any adverse orders. We want some clarification from the respondents. You be here when the matter is taken up. Yes, Mr. Sikar.
Paying for indulgence of your Lordship, my lord, to take up the matter on Friday, my lord.
Which,
Matter relates to selection and appointment of
Mr. Sigdar, you'll have to make the mention before the senior court. My Lord Justice Medi,
my lord.
please do that.
My May I please, Your Lordship?
Mr. Bhattakur is not here.
Yes, Lordship. Item 5, Lordship.
Mr. Talda, he's in bereavement. So when will he be available?
10, Lordship.
Huh?
10 August.
10th of August.
Yes.
Okay.
But 10
I've gone through it.
Yes,
These things, pleadings are there.
On
Okay,
the
fine.
earlier occasion also, Your Lordship.
I've gone through it. We'll just have a small clarifications, a few clarifications I want. You can give it to me. Your basic case would be, even if we ignore the objections taken with regard to the procedure that was followed, your basic case would be that you have lost confidence on that person.
Lordship,
And
that is the
therefore you may not. So some judgments are there, Supreme Court. Kindly place those judgments also.
case. SBI versus Ramesh Dinkor.
All those, there are latest judgments
So
also.
many cases are
So
there.
few judgments on that point also, so that we can also consider, he can also
That is the
make
case.
his submissions on that.
Lordship, fix at any date, Lordship.
When, we'll have it on when? 10th,
Lordship,
3rd of August,
13 August.
13 August. Okay.
13th October. 130. 130.
Item number
Item now 5, Lordship.
on the prayer made on behalf of Mr. S. Bhattakur, who is in bereavement, and not objected to by Mr. L. Talukdar, learned counsel appearing for the respondent bank. The matter stands adjourned. Registry to list this matter again on 13. Mr. Talukdar, 13 it's fine. 13 August 2024.
Obliged, Lordship. Highly obliged.
Yes, madam.
Lordship, with the consent of the other side, I beg to mention item number 28. The Lordship, matter may be taken.
Wait.
into one week. Your Lordship,
Wait.
it's, out of station, Your Lordship.
On a prayer made on behalf of Mr. S.P. Roy, learned counsel appearing for the petitioner. S.P. Roy, Mr. S.P. Roy,
So it's been-
learned counsel appearing for the petitioner, who is stated to have some personal inconvenience today in appearing before this court, registered to list this matter again on 6/8/68.
Today's daily course list. Top of the list, item 6.
Ekita Thursday, Thursday. Not like it. 6, huh? 8 printer. Positive time, but earlier deferred to Thursday. Yes,
Lordship, I need time.
wait,
I do not know whoever was the petitioner. The petitioner last few years back, he informed me that he was acquitted in a criminal case. And the appeal preferred by the state was also dismissed.
Hmm.
Therefore, the finding, I asked him to furnish the copies of all those things in the disciplinary proceedings.
now
Now-
therein, what is the manner in which the seizure was dealt with? That is the only issue.
Lordship, only thing, my problem is that I'm presently serving as AGP, some assistant government leader. So it will not be proper for me to conduct the case on behalf of him. In the year 2015, when I
Matter
was-
of 2015.
Lordship, at that time I was not there. So I need little time.
See,
to-
the only area wherein there is some doubt is with regard to your contentions pertaining to the seizure that was made.
Yes,
Because the witnesses who are there, they have
all police personnel.
all police personnel and the persons, independent persons who are there, they said that the seizure was made.
In the
Thereafter,
night,
we were
night,
called and we were asked to sign
Sign in the morning.
morning. So that's the only area.
Yes, Lordship.
Now, in the criminal case, we'll have to see on that portion only. If that supports that the seizure was never made from your place,
Yes.
everything falls through.
Then in that case, disciplinary proceeding will go. And that may.
Yes, madam,
Yes,
that is the only thing. And what happened to that other
but
person?
record is also required, I think, in this.
Not required. Whatever is here, you have done it here only. What happened to the person from whom you got the, alleged to have got the
That was
ammunition?
also not linked to that.
Huh?
That was also not informed.
That person, what happened? Yes, madam,
Yes,
can you
other
get this
person
instruction?
Who was placed in the disciplinary proceeding,
Ah.
Chaudhary.
Chaudhary.
Chaudhary, he's whereabouts, what is the findings about the Chaudhary is not there.
Was a proceeding also initiated against him?
Yes, it was proceeding was against him.
So we'll have to see whether therein some admission is there.
Lordship,
What was his name? Wait, just a moment.
Gopal Chaudhary.
On the next day, on the next date of listing, Miss, I'll not record your name.
Lordship,
On the next date of listing, Miss Bachaji, additional senior government advocate appearing for the respondents shall receive instruction as to the outcome of as to whether any proceedings were initiated against Lance Naik, Gopal Chaudhary, and one
the petition.
Bhagavan Sharma
So,
with regard to similar allegations as leveled against the petitioner in the present matter. Also, registered to list this. You make alternative arrangements. 15 matter, we are not adjourning any further.
Lordship, I'll write a letter.
No. You will have to get hold of him.
Yes.
I'll give you a week's time.
Lordship,
Full stop. The above information be placed on record on the next date of listing. Registered to list this matter again on 8/8. 2020.
Yes, Lordship.
8/8. So, Mr. Sorry, you see whether there is, you can get hold of that man. Otherwise, we will have to.
Lordship.
Mr. B.K. Bhagwati, learned counsel for the petitioner is present. Oh, no, nalagi. Will not put your name.
Item 7 and 8.
Yes.
May I please, Lordship? This is a matter pertaining to Lordship holding the post of accountant in Procedural Municipal Board.
Ah.
Now, Lordship, there's a new development. For the last 18 years, Lordship, I have been working as an in-charge accountant.
Hmm.
Now, Lordship, when the matter is in session and taken up by the Honorable Court,
Hmm.
they have passed a recent order, Lordship, on. Next. Respondent number 5 has been promoted as head register. Whereas, Lordship, I continue to serve as in-charge accountant, Lordship. I have not been appointed as regular accountant.
You are still working as a,
As in-charge accountant for the last 18 years. Lordship, in this regard, I would like to place one judgment of the Supreme Court, Lordship. I have only one copy, Lordship. May I read one paragraph only? In its impugn common order dated so and so, the High Court took up the petition of Mrs. Harihar Collections as the lead case, and after taking note of all background aspects, first of all, look up the issues related with property in passing the order dated 1/10/2020 by the Commission when the writ petitions were pending in the High Court. In this regard, a serious exception was taken that the Commissioner had all suits to pass the order when the High Court was in session of the matter. The High Court also observed that the suggestion for dismissing the writ petition because of the subsequent development or relating the writ petitions to appellate forum amounted to interference with the administration of justice. The High Court strongly expressed its view in the following terms. When this court had taken cognizance of the grievance made by the petitioner and was in session of the matter, fixing on so and so for consideration, it was highly improper on the part of the Commissioner of Customs to have passed the order dated so and so without any intimation to or taking leave of the court. It needs no reiteration that when the court, that too the High Court, is in session of a matter, an administrative or executive authority cannot start a parallel proceeding on the very same subject matter at its own ipse dixit and record a finding. It would amount to interfering with the dispensation of justice by the courts. Now, Lordship, my basic challenge was with regard to upgradation of respondent number 5. Now he has been promoted as head assistant.
Oh, but that is a totally a
Now,
different thing.
Lordship,
He's a
I should
UDA.
be-
He is a UDA senior to you. You make a challenge to that. You make a challenge to that. He is a UDA senior to you.
Lordship, I don't want to.
And another thing, there is already a decision of this court in this matter. Earlier round.
550. That was only with regard to one particular.
Be
aspect,
that as
Lordship,
it may, constructive,
that the order
where
which
will
was-
constructive res judicata go?
That particular.
I got it,
petition of-
Mr. Das, but what about the principle of constructive res judicata?
It was on a narrow point, Lordship, that.
You
the
can't
order which
have,
was
you
passed by the
can't
earlier
have,
chairman
Mr.
is
Das
finished
satisfying
part-
this court,
Okay.
whether you can institute multiple proceedings on the same issue, basing on different grounds.
It has been entertained by the honorable court, Lordship.
That today we are finally hearing the matter. Today we are finally hearing the matter.
Lordship, another aspect, Lordship, there was an affidavit filed by the earlier chairman, Sobita Devnath, making some allegation against me. Now, the same author of the affidavit, she has given me a certificate. I have placed.
We will not
I am
go into, we
confident-
know about Borpeta Municipal Road,
I am
Borpeta Road
confident-
Municipal Board, so
I
we'll
am
not go into
confident-
all those.
Now, the same person has given a certificate. Lordship.
Now,
We
what do you want?
Lordship, I may be appointed as. I may be
We,
promoted
that we
as-
cannot.
I may be promoted as regular accountant.
We cannot,
Because
we
now
can
Lordship-
only require them to consider your case. Now that the Dhanjit Das is out of the way,
Lord-
we can dispose of the matter, requiring them to consider. Beyond that, I'll not go into merits.
Lordship may also go to the
Lordship
certificate.
may
issued
pass
by the
that
state-
because-
We will not.
Only for one.
We will,
person.
tomorrow, I know, tomorrow she'll come back and file an affidavit. Oh, these are all things I have done. This, we know. We'll not go into
Because
this.
I can bring it on record by filing an affidavit.
No need.
Lordship then pass an order, Lordship, for.
We will not
of
go
my
into the
regular-
merits of the matter. We
And
will
for
only
6
remand.
years, they have not pursued the matter even, Lordship. If they are so urgent, these things, Lordship.
Okay. If that is your submission,
No,
then
not
from
by
today
submission.
onwards-
Now.
today onwards, I will start
to-
identifying matters of the government wherein you have come up with very vehemently, but no affidavit has been filed.
No, Lordship.
Shall I also take that, please? So don't make
we also
unnecessary,
try our
don't
best,
make
Lordship. It is not that-
submissions which are there. This
But-
court had entertained
But
this
anyway,
process.
Lordship, because the private respondent has already been, as per his submission, Lordship, he has already been.
Promoted, the
promoted
post
to
of
some other
accountant
post,
now
Lordship.
is available.
Yes.
So
Lordship,
you
pass
will
an order.
consider his case
Lordship.
within a period of 2 months from
Lordship,
today.
Lordship. may
And
pass.
thereafter pass appropriate orders. He
Lordship.
is at liberty to come back.
Lordship.
Will do? I'll not go into any other thing. If I have to go, I'll have
Only
to,
the certificate received by the chairman.
I'll not, please.
Then also you will pass the order.
Heard Mr. S.K. Das, Learned Counsel for the petition. Tutade, writ petition. Heard Mr. S.K. Das, Learned Counsel for the petition. Also heard Ms. M. Bachaji, Learned Counsel, appearing for the
Lordship, here actually I am appearing for the board only, Lordship.
Borpeta Road Municipal Board. That is the respondents number 3 and 4. Also heard Mr. G. Goswami, Learned Counsel, appearing for the respondent number 5. Also, the present proceedings have been so instituted by the petitioner in continuation of the challenges made in earlier proceedings pertaining to the, yes, we will record it. Pertaining to the upgradation as affected in respect of the respondent number 5 in both the cases.
Lordship, for 1 and 2, she will be appearing, Lordship.
Respond number 5.
Respondent number 5, that is Sri Dhanjit Das, to the post of accountant. Also, Mr. S.K. Das at the outset has submitted that the Borpeta Road Municipal Board in its meeting held on 11/6/2024 had adopted a resolution towards promoting the respondent number 5 herein, that is Sri Dhanjit Das, the senior most upper division assistant of the board, to the post of head assistant of the board. Also, it is contended that in terms of in terms of the said resolution, and order dated 19/6/2024 was so issued by the chairman, Borpeta Road Municipal Board, promoting said Dhanjit Das to the post of head assistant, and he has already assumed the charge of the said post. Also, in view of the said position, Mr. Das has submitted that the post that the claim of the respondent number 5, that the upgradation of the respondent number 5 as an accountant has been rendered null and void. Accordingly, Mr. Das submits that the respondent number 5 would have now no claim to the post of accountant, and the same is lying vacant. Mr. Das further contends that the petitioner herein is holding the charge of the said post since you're holding the charge of the post
Since 19/6/2000, sorry, 6/4/2006.
since 6/4/2006 till date, and accordingly he prays that the respondent board is required to consider her case for promotion to the post of accountant on regular basis. Also, Ms. M. Bachchaji, learned counsel appearing for the respondent board, submits, does not object to the prayer as made by Mr. S.K. Das herein, and submits that the board would consider the case of the petitioner for such promotion in the manner in accordance with law. Full stop. Also, in view of the above submissions of the learned counsel for the parties, this court is not proceeding to consider the issues arising in the present proceedings on merits, and would direct the respondent municipal board, that is the Borpeta Road Municipal Board, to consider the case of the petitioner herein for promotion to the post of accountant lying vacant in the said board, and while proceeding to effect such consideration, would also consider that the petitioner herein was working on officiating basis against the said post with effect from
6/4/2006.
6/4/2006. Also, the said exercise be so initiated and concluded within a period of 3 months from the date of receipt of a certified copy of this order. Also, with the above observations and directions, the writ petition stands disposed of. Upar likho, ad Ms. U. Sharma, learned. U. Sharma, B. Sharma.
You Sharma.
U. Sharma. Or we'll put B. Sharma.
You Sharma.
U. Sharma. Learned counsel, learned government advocate, junior government advocate, appearing for the respondents number 1, 1 and 2. Closed,
This will also cover the second repetition.
both together.
Obliged.
Item 9.
Retired on 31/5. Instituted this proceeding on 1/6. Show me the law that you are entitled to a retrospective consideration.
2010 for SSC 290, my lord.
What is
Union
the
of India
prescription?
versus Hemraj.
Hemraj. Latest decision 2022. Manpreet Singh Poonam.
My lord, this has not been differentiated. Hemraj has not been.
That whole, that's a 3-judge bench wherein it has been held that you can claim a promotion only from the date of promotion. You cannot claim. Therein also the prescription is made that there was a VRS retired employee that she cannot claim something from the past. Your master-servant relationship came to an end on 31/5. Thereafter, where is the scope for this court to direct them to reconsider? Show me that judgment.
Yes. Paragraph 35, 36 to start off with, my lord, thereafter paragraph 43 and 48.
35, 36.
My lord, may I read now? The court must keep in mind the constitutional obligation of both the appellant's central government as also the state government. Both the central government and the state government are to act as model employers, which is consistent with their role in a welfare state.
Oh, this is with regard to that site 46,
Yes,
Rizvi.
yes.
This is with regard to that IAS IPS promotion.
My lord,
And therein it is required that by the rules
my lord.
to hold that promotion in a particular manner.
My lord.
Herein the cadre review, which is mandatorily required to be done within a periodically, was not taken into account.
Here, also there is a requirement under the law, my lord,
Where?
in this case.
Show me that.
My lord, will consider Rule 6 of the Assam Finance Service Rules 1963. My lord, my lord,
2022, 6 SSC 105. 2022, 6 SSC 105. 105. Yan asin niya man, I know. SSC asin niya. Tapa library. Yes.
here also, if your lordship kindly peruses Rule 6,
Hmm.
there, my lord, there's a stipulation which requires a member of grade 3 to have rendered at least 4 years of service.
That is eligibility.
eligibility.
Eligibility will not, because say, your promotion is a statutory right.
Right.
Consideration to promotion is a fundamental right.
My lord,
Ajit Singh and all
Right.
those lines.
my lord.
Now, their case as projected is that we were preparing the, what do you call that, seniority list. There were some errors. So we were rectifying it. So they have justified the reason for not calling the DPC. Now show me your legal right.
Now,
This will not take you anywhere.
my lord, their justification or their explanation
Hmm.
was that there was
Now, is
error.
there any provision here that the person has to be promoted from the date the vacancy so arose?
In the
Rules.
my lord, in the rules your lordship is talking about.
Rules.
No. Rules obviously will not have any such provision, but insofar as the ruling of Hemraj is concerned.
Hemraj is on a different context altogether.
The
Ratio will not come because the rules are different. And the prescription in the rules are also different. IS IPS.
The ratio, my lord, that I am.
Ratio I will cover by Manpreet Singh
The
Poonam.
recent three bench.
And I am bound by that. You are not bound, but I am bound.
Then I am bound, my lord, once your lordship.
So
says
you
that.
can make any arguments, but I have to go by that only.
But my only humble contention, my lord, inaction and delay.
These have been considered. That will not take you anywhere. Until and unless that order of promotion does not come. Only exception can be worked out by me is you being placed in seal cover because of some proceeding, you retiring, and subsequently you getting acquitted. What would happen? My thought process is that you will have that seal cover has to be opened and you have to be given from that day. Anyway, while reading it, it came to my mind. This is not the here. So that's the only exceptional circumstances I can say. So we will get that judgment and then pass the order.
Lordship will reserve it.
No. Today itself. Moment I get that, you need not be here. Moment I get that, I'll pass the order. Facts are not in dispute. Mr. Gugoi, anything to add?
No, my lord, the final gradation list came up on 20 to 5. 30
20?
might be retired. 20 to 5.
20 to 5, before his
30 might
retirement.
be retired.
Retired.
Only within my lord 8 days.
There are some lapses on your part, but that cannot give rise to you. We'll quote Manpreet and we'll dismiss it.
Apply.
May I please the question? This matter is pertaining to selection and appointment of,
Now the respondent has taken over.
now that is in terms of lordship order passed in an IA. Holding that any appointment made that shall be subject to. the
Okay, fine.
appointment.
Now you just show me how this court will determine
Yes.
whether you are ward number 10 town committee or ward number 10 panchayat. That's the only issue.
My lord, yes. Panchayat and lordship, there is no difference between Panchayat and. town.
Disputed questions. We will not go into.
No, so far the notification is concerned, he must.
Say
be-
there is a deputy commissioners under the deputy commissioner in pursuance to this order of this court. Verification done, wherein it was found that you are not in that area. You say that the circle officer is in connivance with the private respondent. And but you have neither made the circle officer a party respondent here by name, nor the deputy commissioner.
Circle officer lordship, yes, in fact, lordship direction was given to the deputy.
I got
commissioner
it.
in
I
earlier-
got it. Deputy commissioner required the circle officer to make an investigation and give it to him.
No.
He has endorsed that to the director. Now, your allegation is that this subject to correction. Your allegation is that the circle officer in connivance with him without making any
My
inquiry.
lord,
How will we believe it? You have not even made him a party.
my lord, my primary question is that lordship, the Assam Services disciplinary disciplinary.
Will not apply here.
Yes, lordship, there is a decision of this.
Maybe, but in this facts, it will not apply.
My lord, that has not been taken.
This facts, the direction, inquiry by this court, direction by this court attains finality.
Oh, lordship, that-
Now you will have to bring on record materials beyond that. That is nothing here.
Yes, lordship, I have annexed lordship that.
So this is the
My lord,
thought of this court. Now dispel.
case 39 is the repetition lordship.
39.
My lord, 38 is the translated. This is the Gaubura certificate lordship.
Oh,
And page 40 is the my voter
will
identity.
not believe this. Gaubra.
Page 40 is the voter identity card.
Voter ID also, it says Niz thing. It does not say, it cannot be construed that this is not the town committee.
Lordship, kindly see
Uttarakhand,
the- kindly see the
Khanda. Huh?
Notification, page number 19. Lordship.
Village.
My lord, page number 19 is the notification.
Huh?
That is the requirement lordship that is given.
Village. But you have been now projected to be under the town committee.
Yes.
So how will it be village?
Disputing that I am not village. My lord, there is a revenue village is Nizdin. A part of the village lordship comes under the panchayat
Say,
and.
maybe, but
and-
there is no material here to show that the Anganwadi center also covers ward number 10.
my lord, the revenue village is concerned.
I am not on that. That all those things have been gone into. Now show me any material on record that the Anganwadi center covers your area also.
My lord, I am not disputing that I am not belongs to ward number 10.
So not disputed that you are in the town committee.
My concern is that lordship, the ward number 10 and ward number 1 lordship, both are lordship in the revenue village, Nizdin.
How can it be? That revenue village cannot be a part of the town committee.
One part of the lordship.
That is different. That is town committee. That is not a village anymore.
That I have lordship.
Oh, am I wrong in understanding that? Can a village also be a Gaon Panchayat and also be a town committee, municipal board?
My lord.
They will elect a municipal councillor, also elect a Gaon Panchayat ward member.
Lordship, one part of the village lordship, as per my instruction, one part of the village falls under government.
So the other part
My lord,
is not a village. It is under the
town committee.
town committee. So that cannot be termed to be a village. How can you have both together? Clarify. Clarify. Guwahati. Guwahati is municipal.
My lord, village.
So a part of Uzambazar is a village.
Village.
Now, can Uzambazar be also included in town committee, also in the Gaon Panchayat? Both.
My lord, the requirement is there, lordship.
No. Forget the requirement. Tell me, can it be a village after it forms part of the municipal? I don't know. Clarify. Yes or no? If you say yes, we will proceed.
People understand that can be lordship.
No, cannot be.
My lord, that only-
So it goes out of the concept of a village. It becomes a part of a town. So now you can only elect one, either a councillor or a Gaon Panchayat ward member. You can't have both.
Obviously, lordship, the people belongs to town, they will elect the,
So that is the end of the matter. No further consideration is required. Because the very prescription is village. You are out of the village.
my concern is that there is a revenue village lordship, both the petitioner and the.
Okay, any further argument?
My lord, paragraph 10 lordship, I have specifically mentioned about this lordship regarding the village lordship in my requisition. And there is a division bench judgment lordship. In one revenue village, there may be more than one Anganwadi center lordship. But it is not necessary that the
Okay,
candidate.
show me that this Anganwadi center is covering your area. The next approach. We will see it from that line.
My lord, paragraph 10 lordship, I have it.
You have not said that.
10 and 11 is, the petitioner is not disputing that she is not the resident of ward number 10, which falls under the town committee. In fact, ward number
This
10
cannot
is-
be accepted, Mr. Counsel. This cannot be accepted. So now the only way I can come into your assistance is that the area is covered by the same Anganwadi center. There is no material.
So for this document, two documents lordship that I have page 38 and 40, that is the Gaon
That we will not.
voter list also.
Once the circle officer and the deputy commissioner has come, this we will not give any credence. Because here again, village, what is being said here is contradicting your para 11. She is saying that you are a resident of the village, whereas you say that you are a resident of the town area.
Yes, that falls under town.
Then
lordship.
how can we give any cognizance to this?
Both the lordship area under panchayat and lordship town committee lordship falls in the revenue village of Nizdhi. That is my contention.
Can it? And how do you establish that this house of yours is covered by this Anganwadi center? That is another way to look at it.
Oh, it is not necessary that I should belongs to
No.
Anganwadi center area.
No,
I
lordship,
should
this is a
belongs to revenue
precondition,
village.
lordship.
No. He is right to a certain extent because you have put in your condition village, not Anganwadi coverage area. So just don't make
Should be, my lord,
self-defeating submissions.
my lord, the candidate must belongs to a revenue village.
Okay, any further?
That
So
is-
you have made an allegation against the circle officer.
My lord.
What is the material to substantiate that? Have you made him a party?
No, he is not party lordship. Deputy commissioner lordship, he is party lordship. There is a,
Deputy commissioner by designation is a party, not by name.
yes. The direction of this honorable court was to the deputy commissioner.
Fine.
He has a lordship entrusted the circle officer.
Anything more?
He has-
And from when is respondent number 6 holding the charge?
My lord, that is lordship. I don't know lordship after passing of the correct 1/12/2015 orders in an IA lordship. Time for vacating of the interim order.
Okay. Anything more?
My sole contention is that lordship I belongs to.
When was the recruitment made?
My lord,
Recruitment was made in which year?
2007.
2007.
2007, Lordship.
Give it a closure. Yes, Ms. Vatsari. What do you have to say?
Lordship, as per our, these things, the inquiry, everything has been done, Lordship, and we have the inquiry report also with us.
that inquiry report is also not furnished to me. That I have specifically mentioned, and in their affidavit also, they have, the director of social welfare is saying that there was no direction of this honorable court to furnish the inquiry report. That is stated in their affidavit also.
Yes. We are not concerned with the inquiry report. We are concerned with what has come out from that inquiry report. Yes. Anything more?
No, Lordship, nothing.
Who is appearing for R6?
I'm-
You are appearing. From when are you holding the charge of the post? When are you?
Time be personal election code number 4.
Oh,
MM.
anything more, Mr. Krishna?
My lord, I just,
There is allegation by respondent number 6 against you. You are in glove in hand with the petitioner. You are respondent number 7. Why have you woken up so late? We are not coming in your favor. We will continue with respondent number 6.
my lord, I am submitting two judgment of this honor. One is division bench and one is single bench judgment. Again, division bench judgment lordship.
There is no termination here. It's only a reiteration of the fact in terms of a order passed by this.
The ratio laid down in the division bench lordship that he must belongs to the revenue bills. It is not necessary that he must belongs to the concerns owned by the center revenue. This is the ratio in the division bench.
Okay.
And,
Where we'll hear Mr. Mahmood by at 2 o'clock. 2 o'clock.
2 o'clock.
Mr. Han, sorry.
Item 11.
কথা দুটা বজাত কৈ দিম ইয়াতে Yes, Mr. Das.
This is basically
Basically nothing. Basically nothing. If this is the formula we'll have to follow, then there will be no rule of law.
in a way lordship is correct, but the
Then-
thing is, that is how he was appointed.
Can't help it. So
And-
now that we have come and even the health authorities are not with you. In the affidavit they have filed, they have taken a contrary view that this is by the principal himself. You seem to be a very blue-eyed boy of the principal.
Since 2004, I
You
worked
work.
there.
You work.
I
You will
worked-
get Upendas. You will be given Upendas. And if that post is put up to recruitment at any point of time, your case would be considered. We will provide that you will be given some weightage for the work you have already done.
Because without salary, without any remuneration, I.
We will say that you will be entitled to Upendas. Yes, Mr. Gogoi. He is working in with you. Rightly, wrongly, you have engaged him.
Till lockdown, my lord, I was there, because after lockdown, there is a change scenario, because all these
Now you are not working.
No, this Nagaon and Jorhat Homeopathic College is merged.
Merged with Guwahati.
Guwahati. So. that
You are
is
not there
probably
anymore.
Not there.
So there is no question of any payment. But if that post is recruited, grade 4 post is recruited, give him some weightage for the work he has already done. He is doing work from 2004.
Only thing, my lord, so far as the amalgamation part is concerned, as far as my
No,
knowledge.
that is not
Only
before me.
whoever was there, they were brought in. Sanction post. my lord,
Post,
who
I
were
know.
Working on regular basis, they have been retained. Now, my lord, the post, whether it will be again filled up here in.
No, if any vacant post of driver is put to recruitment,
Driver or any grade.
any
4
grade
post.
4, give him a, in that, only
Yes.
that
He
Assam,
will apply.
he may apply and You
Only that-
condone his overage and as well as give him some weightage. Right?
My lord.
And now what is the new thing called here? Homeopathy College?
It's Assam Homeopathic College here.
This
It
is
has been
Assam
amalgamated.
Homeopathy Medical College and Hospital, Naga.
Yes, it has been amalgamated to the, my lord,
To what?
to the medical college in Guwahati is
I
Assam.
think it is Sohit Jadavnath.
Jadavnath, yes, Sohit Jadavnath Homeopathic
Sohit
Medical College.
Jadavnath.
Both Nagaon and Jorhat has now been, my lord, amalgamated
At Guwahati.
at Guwahati.
Heard Mr. H.K. Das, Learned Counsel for the petition. Also heard Mr. B. Gugoi, Learned Standing Counsel, Health and Family Welfare Department, appearing for the respond number 1, 3, 4, and 5. Also heard Mr. P. Naik, Learned Standing Counsel, Finance Department, appearing for the respond number 2. So the petitioner hearing by contending that he was. Also, the petitioner hearing has presented a challenge. Has raised a grievance with regard to non-release of his salaries after his services were regularized. Wide and order dated? Regularized. Wide and order dated 25/1/2012, issued by the principal, Assam Homeopathy Medical College and Hospital, Nagaon. Also, the petitioner hearing contends that he was engaged on casual basis in the said medical college with effect from 139 casual worker in the year 2000 casual worker for performing the duties of a driver in the year 2004, and since then he has been discharging his duties in the said institution. Also, the authorities of the said institution on a post of on a vacant grade 4 post becoming available in the said school, said institution, proceeded to consider the case of the petitioner hearing, and thereafter, basing on the recommendation so made in his favor by a selection committee constituted in the matter, proceeded to issue the order dated 25/1/2012, appointing him on temporary basis as a grade 4 employee against a grade 4 post in the said college with, and also authorizing to him a scale of pay. So, thereafter, the materials as brought on record reveal that the appointment as affected by in respect of the petitioner hearing against the post of against a grade 4 post wide the order dated 25/1/2012, not having been so done after receiving the clearance from the finance SIU department, the pay and allowances of the petitioner hearing were not being so released. So the respondent authorities had also moved. Respondent authorities in the health department had also moved for an ex post facto approval, the same was also not accorded by the finance department, and accordingly the pay and allowances of the petitioner hearing was not released. So the respondent authorities in their respective affidavits have questioned the manner in which the petitioner was question the manner in which the case of the petitioner hearing was solely taken into consideration for regularization for his appointment against a vacant grade 4 post in the said institution, wherein, it is further contended that no other person was so considered and no advertisement in this connection was so issued. However, it is stated in the bar today, when the matter is taken up for consideration, that the Assam Homeopathy Medical College and Hospital, Nagaon has lost its existence on the same being amalgamated with the Sohit Jadavnath Homeopathy Medical College at Guwahati. It is contended that the Assam Homeopathy Medical College and Hospital, Nagaon is no longer functional. Full stop. In that view of the matter, the petitioner is not rendering his services in the amalgamated institution after the said amalgamation was so affected in the year. So amalgamated. Full stop.
But
In
the
view of
statement made by the petitioner is that, my lord, during COVID, my lord,
Forget. In view of the above position, this court in the present proceeding is not in a position to consider the grievance of the petitioner herein, inasmuch as the post purportedly held by him is no longer in existence and the institution itself has been rendered non-functional. However, considering the fact that the petitioner has been rendering services in the Assam Homeopathy Medical College and Hospital, Nagaon, where from the year 2004 as a driver and continued in such capacity till the existence of the said institution was till the said institution was amalgamated with Sohit Jadavnath Homeopathy College and Hospital at Guwahati, this court directs the respondent authorities, more particularly the authorities in the Health and Family Welfare bracketed B department, to so and so, that in the event any grade 4 post is so advertised pertaining to the so advertised in Sohit Jadavnath Homeopathy College at Guwahati, the petitioner herein should be permitted to submit his candidature against such post and his case be considered in the recruitment. So in the event the petitioner has been rendered overage during in the meantime, the petitioner, if having become overaged, the respondent authorities shall condone his such
As per
overage,
law, my lord.
condone his such overage on an application made by the petitioner in this connection. Further, the petitioner shall be considered in such a recruitment process by extending to him weightage for the services as rendered by him in Assam Homeopathy Medical College and Hospital, Nagaon, with effect from 2004. So with the above observations and directions, the petition stands disposed.
The notification is 29/11/2022.
22
The merger.
A merger to upon Legion in the year 2022.
No, regarding the age condonation, it should be as per the law, prevailing policy method. Again,
Yes.
my lord, there will be flat case otherwise.
Condone the age of the application on an application
There's a
made by the
policy.
petitioner by applying the provisions of law
Right.
governing the field.
Hello, problem.
DPO.
Item 12.
Lordship, pass over the matter for the time being, Lordship.
Thirteen.
Before your lordship, my lord.
Come to page 50 and thereafter make your submissions.
Yes. My lord, actually, my lord, earlier.
Actually, constructive res judicata,
Earlier, Kitchen had approached this court, my lord, claiming pension, my lord, but
same thing
he
here also.
did not
But
challenge
Mr. Hawk, the findings that have been recorded therein with regard to your mental condition, that still holds.
My lord,
Page 50, 51, 52. Everywhere the medical certificates are submitted by you pertaining to your mental condition,
my lord.
that has been discussed and rejected.
No, lord, only discuss that. Report
Show me the law that you can again file a second
Only
petition
thing
on the
that
same point.
The report cannot have cannot go to the document submitted by the petitioner. My lord, actually, that could have been done by the constituting medical board also, my lord.
We will not. There is, why didn't you file an appeal? There in this consideration, this submission could have been considered, but not by a coordinate bench.
My lord, page 52, my lord, last paragraph, my lord. Last line, my lord. Also the
That is why, along with res judicata, constructive res judicata, principle of constructive.
My lord,
So whatever you had to challenge there, you should have challenged there.
my lord,
You
there,
cannot
my lord,
have separate
What-
challenges.
what that court had provided, my lord, kindly, my lord.
It has not provided you liberty, have it, has it?
Also the order dated 31.
So and so, by discharging has also not been challenged.
Has been
Forget
challenged.
it.
That is why, my lord.
Forget it.
That was not challenged, my lord. Now it.
Just read the line before that. As stated earlier, there are disputed questions of facts which cannot be decided by way of this writ petition. Okay, I hold that second, this writ petition is maintainable. But again, the materials that you are relying on here were relied on in the earlier round of proceedings. And this court has come to a conclusion that these are disputed, we will not go into. And no appeal, attain finality.
Could not have the opportunity to produce the document, my lord. My lord, ultimately in the year 1997, my lord, the expert inquiry was committed, inquiry was done, and accordingly.
Forget it, those things have become a thing of past. Categorical findings.
That in fact, my lord, husband, my lord, recently died, my lord, on 7/1/2023, my lord.
This is abuse of the process of law. Misuse of the process of this court.
The thing is that, my lord,
Who advised? You advised.
no, my lord.
Then?
No.
Then?
Well, in fact, those medical certificates are still there.
We cannot, once it has already been gone into, you have not gone on appeal.
Right.
Dismissed. Yes. Mr. Borwa, anything?
In the meantime, they have filed one writ petition, and writ petition, it has been established that like, his medical thing cannot be decided by the High Court, Lordship.
Leha. Heard Mr. S. Hop, learned counsel for the petition. Also heard Mr. C.K.S. Borwa, learned counsel, government advocate appearing for the state respondents. The petitioner, by way of instituting the present proceedings, has presented a challenge to an order dated 31/5/1997, issued by the Superannuation Police Kokrajhar, whereby the husband of the petitioner was discharged from his services. Also, the petitioner has also prayed for sanction of invalid family pension to the petitioner with effect from 14/2/1994 in respect of the services rendered by the petitioner. Also, before proceeding to consider the issues arising in the present proceeding, it is to be noted that the present petitioner had earlier approached this court by way of instituting WPC number 1652/2013 on the same issue as arising in the present proceedings. Also, this court wide order dated 15/2/2016 on considering the grievances so raised by the petitioner, including the grievances pertaining to the medical treatments being received by the petitioner, husband of the petitioner herein, had recorded a categorical finding to the effect that the certificates as relied upon by the petitioner in this connection cannot be relied upon by the petitioner, in view of the inconsistencies as noted therein, proceeded to record the following conclusions. Page 52, A2. A. Also, basing on the said conclusions and also on the fact that in the earlier round of proceedings, the discharge order dated 31/5/97 was not under challenge, proceeded to dismiss the present writ petition. Also, a perusal of the materials brought on record in the present proceedings reveal that the only difference between the earlier proceeding and the present proceeding is that in the present proceedings, a challenge has been presented to the order dated 31/5/1997. However, the same is so based on the medical documents which were gone into by this court in the earlier round of litigation, that is WPC number, the earlier proceedings, that is WPC number, and that is in WPC number 1652 of 2013, and wherein the conclusions as noted herein above had been so arrived at. The conclusions as drawn by this court by the order dated 15/2016 in WPC number 1652/2013, having not been so questioned in an appeal, the same has attained its finality. Also, in that view of the matter, the present writ petition is hit by the principles of constructive res judicata, and the petition and the same cannot be taken up for consideration on merits. Accordingly, in view of the conclusions as drawn by this court in the earlier round of litigation and as noticed herein above, the present writ petition is held to be devoid of any merit, and the same stands dismissed.
Alright.
Not supposed.
Fourteen to 21.
Well, I am appearing in item 15. Whether the petitioner was wrongfully refrained from participating in the interview, though he secured 93 highest mark in the written test by the IFCL authority. Excuse my lord, the IFCL authority.
You're for whom?
The IFCL.
Has that order been uploaded? Have you got it? That division bench, Arunachal?
I've been informed.
It has been uploaded.
I told him to check. It must have been by now, it must have.
Should have been.
My lord, the petitioner.
But a very interesting question. But it caused a lot of pain also.
Very fine point, although it looked very simple at the beginning.
But it caused a lot of. Can't help it. We can't go beyond the law. But maybe somebody will take it up for challenge and get it reversed. Yes.
My lord.
What is the issue?
My lord, the petitioner.
You are for the selected candidates or IUCL?
I am for IOC.
IUCL.
My lord, the petitioner participated in a selection process.
Pranab Raut, Pranab Pathak.
No, I am item number 15, Rahul Das.
You give me a highlight. What is your grievance?
Yes, madam.
All the issues are, the issues in all the cases are
In
same.
that case, my lord, since I'll be addressing your lordship in
On
all the matters, may I just give a
Give
brief-
a.
that will
As an officer of the court, but.
yes.
Ah.
What had happened was there was a selection held approximately about
I think once I had considered these matters.
it was just a day before our
Ah,
elections. That is how it got deferred. So
What happened?
there was an advertisement. There were different categories of posts. About 30 odd posts were advertised. Selection was held. It entailed 2-3 rounds of selection, written, followed by what is known as a skill, proficiency, and physical test. Now, the select list was finalized. Appointments were made. That is when we got 2 complaints, and both of them are petitioners here. One of them is Rahul Das,
Item 15.
and the other one is one Mr. Prashank Kumar, right? Both of them have also filed writ petitions. They filed a complaint saying that our candidature was erroneously rejected. We were rejected at a particular stage where we could not have, because we are entitled to a particular relaxation, which was not granted to us. Now, based on these 2 complaints, we instituted an internal investigation.
Inquiry, yes.
Inquiry. Our own vigilance wing of IOC conducted a and found that not only were these 2 persons correct in their contention, while examining the entire selection process, we discovered some further anomalies in respect of some other posts also. That is when the matter was referred to the Central Vigilance Commission. Central Vigilance Commission conducted its own investigation. And this was again internal investigation just to find out whether the selection process was in order or not. CVC came up with their own findings. They said that there are errors in respect of 7 candidates. They recommended taking action against the officers who were involved in the selection process. And so far as these errors are concerned, we are not attributing anything to anyone. We are simply saying that there were mistakes.
Means you mean to say the errors were of such nature, which would have resulted in their non-selection.
Rahul Das and Prashank
Would come in.
would come in. And in respect of some others, what we found was there were a little erroneous calculations in the marks. They were given higher marks than what it adds up. There were mistakes, mathematical calculation mistakes.
So what we did was, we decided that instead of going for a full-fledged inquiry, and since the law permits, since these people were on probation, we said that we'll issue orders of termination simplicity without attributing anything to anyone, any of these candidates. And it is after we issued the orders of termination that the other writ petitions came to be filed. And that is how the matter is before your lordship. There are two groups of writ petitions. One is this Rahul Das and Prashant Kumar, who had lodged the complaint. Rahul Das and Prashant
15
Kumar.
and 16.
Item 15 and 16.
Where Mr. Patwari appears.
I am item 15. Item 16.
Oh, fine. Now, Mr. Chaudhary, you have issued with respect of the others, orders terminating their probationary appointment. Now, what happened thereafter?
Those termination orders are under
Fine.
challenge in the other writ petition.
Fine.
And they are
Now-
saying their only cases that we ought to have been, national
to
justice ought
notice.
to have been followed.
Okay.
And our contention, as is the law relating to termination of probationers, if we have not that discretion, since you were on probation, the law gives us the discretion of not going for a full-fledged inquiry and simply issuing orders of
Okay,
termination.
fine. We got it. Now, the way you told 30 posts.
I will give
Be
give
that
the
as-
exact number.
Forget it. 30 posts or something odd. You have only interfered with the appointment of 7 persons.
Yes,
7.
the
Now-
ones in respect of which we found the anomalies.
Now, how were these 7 posts thereafter decided to be filled up, or you kept it vacant?
No, there are interim orders, so we have not proceeded thereafter.
So
So now
Rahul
what
and
would happen
Prashant
is-
Kumar have not come in.
Rahul Das and Prashant Kumar, if we proceed now from this stage, what will happen is they were ousted at the entry level itself.
Okay.
So we will have to call them for the SPPT test. If they score well, they will come.
Whether that would
One
be
of them, one of them
Whether
will come,
that would be permissible at this stage.
because we have to proceed from that stage
But because you have already taken the process
to
to a logical
conclusion.
conclusion.
It can be either of two. Either your lordship directs us to conduct afresh, which we don't have any problem, or your lordship allows us to proceed from the stage.
Whether that would be permissible.
That is what we.
So this is the broad.
Afresh is, we are fine with afresh, we are fine with proceeding from that stage. So yeah, in a nutshell, my lord, this is the case before your lord. Just to give the total number of posts, my lord, it was 44. Total number of posts were 44.
And
And
person,
out of them,
Huh.
only in respect of 7, we have issued orders of protection.
so now that you have brought on record pleadings, have you also brought on record materials to demonstrate why these 7 were required to be, because
Yes,
this is
yes.
again in terms of that CVC minutes.
Yes.
Also, have you brought on record materials to demonstrate that because of these marks, which now they will score, they will not be in a position to be incorporated in the select list on merits?
Yes, what we have said is, just so far as the first batch, Rahul Das and Prashant Kumar is concerned,
Forget him, forget them.
what had happened was, they were entitled to a particular relaxation, which they were not granted, so they were ousted.
We'll come to Rahul Das and Prashant subsequently. Let's test those 7 persons whom you have ousted. So they got, say, 80 marks in the selection process. So they were placed at a particular place in the select list.
Yes.
Position in the select list. Now, after your this CVC investigation and everything, say they got 60. So is it your case that once you have got 60, you are not within the merit position? So you have to be ousted. Now, there would be people in that merit list only who would come up. Have you done that exercise?
No, because there are interim orders, and showing due deference to this honorable court, we have not taken any further steps.
Okay, which
So
is
that
the first
exercise
case,
will have to be done.
which Pranab Pathak is one of the cases wherein the ousting had taken place.
Ousting has taken place because of Rahul and Prashant Kumar's complaint.
And the investigation which you made.
This Pranab Pathak is a direct consequence of Rahul Das and Prashant Kumar. And the others are not. Others
Others are-
we discovered during the course of the investigation.
Okay. So he is a direct result of CVC. Or
All are in fact, but He
Okay, we'll consider Pranab Pathak first. And then
first,
come to your.
first, perhaps your lordship will have to consider Rahul Das and
No,
Prashant
why
Kumar,
I'm telling you.
because they got the ball rolling.
No, fine. Forget it. Now, if we find that the terminations in Pranab Pathak and the like cases are perfect. So thereafter, we will be required to take a call as to what would be the fate of the other two complainants, how they would be fitted in. Now, if we find that the ouster of Pranab Pathak and others like were not proper, they ought to have remained, then there would arise no question of further consideration because the select list would be full. We will give a consideration thereafter
But
in the
even then,
manner.
even then,
We'll have to take a consideration, we'll give a call, take a call on that, but that would be subsequent. Because by taking a call on that, we would be only deciding their cases. Because on the question of eligibility relaxation, you have nothing to do against this Pranab Pathak and all. They are all eligible to appear.
yes, sir.
So it would be after their selection, something had happened in this election for which now they are out. We'll examine that first.
My lord,
Yes,
may I
Mr.
have
Dekar.
lordship indulgence, my lord, before you notice, sir. My lord, Rahul Das, I am appearing for Rahul Das in 1915. This writ petition is prior in time, and we have made him a private respondent, and we have assigned the selection, my lord. Now, if your lordship allows my writ petition, and his selection is interfered with, then the other issues become a.
Is your case in that writ petition that Mr. Dekar is not entitled to participate in the selection process because of some inconsistencies in his eligibility?
No, my case is.
That is not the case.
Yes, my case is that I have been wrongfully restrained from participating in the interview, my lord.
That is not by Pranab Pathak, that is by IOCL.
But he is the beneficiary, my lord.
Okay,
So if
we.
his selection goes, so the other issues, his termination is become economical, my lord.
No, I'm not on that. We'll consider your case.
Fine.
If your grievance against Mr. Dekar's client is not with regard to his eligibility, it's with regard to certain inconsistencies in the process of selection.
Correct.
So we'll see that inconsistencies first, what it is, and thereafter take a call. We'll hear both of you, but let us see what the inconsistencies.
There is another way, perhaps, thinking aloud. There is another way of perhaps looking at it. Now, the ball was set rolling by Rahul Das and Prashant. They lodged a complaint, and they also came before this honorable court filing 2 writ petitions. Now, the prayer made in that writ petition, to an extent, has already been, they have got the relief. Since we have accepted the complaint and we have terminated them. So that is another way of looking at it, perhaps.
Let us just have
And
Mr.
my-
Dekar.
There are 3 posts in respect of, in which we have.
You are in the same category.
There are
Pranab
3 posts.
Pathak,
The other 6 are different.
we'll see. Yes, Mr. Dekar.
Lord, my learned senior friend has already given an overview, my lord. Right. My lord, this termination actually happened 1 year after joining. If I may just indicate the dates. My lord finds at page 30.
You can take me straight from the advertisement itself.
Page 16.
You are interested in which post?
I'm interested in 202 and 207, my lord. Fire and safety, there are 5
You are a
candidates
general candidate?
and 1 PNU.
You are a reserve candidate or a general candidate?
Pranab Pathak is a reserve.
Reserve,
Oh, OBC.
OBC.
Yeah.
So OBC, there was 1 post and junior engineer, also 1 post.
Yes.
Where were you finally recruited?
My lord, Pranab Pathak was a PNU, my lord.
PNU.
PNU.
Okay. So this advertisement is of 21/9/2021, right?
Yes.
Then what happened?
Then, my lord, the
412.
page 24, my lord, I was shortlisted and called for the SPPT, as they call it, my lord, skill proficiency physical test. That is.
So your roll number is 201102. Okay.
My lord, thereafter I was issued the offer letter, my lord. Page.
So there were
28.
3 stages in the selection process.
Yes, my lord.
Then
And finally, your lordship finds at page 34, that's the offer of appointment. This is dated 27/12/21.
You had an NCL also,
Yes,
page 34. Okay.
page 34, my lord, and page 35, clause 3, if your lordship takes up, that is the clause the respondents are stressing upon, my lord. You shall be on probation for a period of 6 months from the date you join the post, which may be extended or reduced depending upon your performance, application, attendance, verification of character, antecedents, caste, and bearing at the sole discretion of the management. If your work is found to be satisfactory during the probation period and verification of your caste, so-and-so character and antecedents are also found satisfactory,
Okay,
you may
fine.
be confirmed in service.
Okay, fine.
Your services will not be regarded as confirmed until a letter of confirmation is issued by the management.
Normal.
Now, my lord, thereafter, my lord, page 39, that's the office order indicating my joining.
Done. Then the termination order.
Then the termination at page 40.
Hmm.
So, nearly a year later, my lord, just more than a year later, I was served with this termination. May I read this? You were
Can come to the second paragraph.
acting upon the complaint letters dated so and so received by vigilance, an internal inquiry was conducted with respect to the said instant recruitment process, and on the basis of the internal inquiry and recommendation of the CVC Government of India, it has been revealed that you have been erroneously selected, appointed to the said post. Indian Oil Corporation Limited is a public sector undertaking and a company registered under the Indian Companies Act. A company state for the purposes of Article 12 of the Constitution of India. It is governed by statutory rules and regulation and has mandate of law to follow the rules and regulations in the matter of public employment. Since you have been erroneously selected, appointed for the said post in deviation of the applicable recruitment rules, your appointment as so-and-so at Guwahati Refinery by offer of employment number so-and-so stands
Okay, fine.
withdrawn and terminated with immediate effect. You are advised to submit. Now, all of this happened, my lord, while the other two writ petition, that's item number 14 and 15 were pending. In fact, my lord, initially, insofar as Rahul Das's case is concerned, at page 42, my lord, your lordship finds that the appointment, my appointment was made subject to the outcome of the writ petition. However, in Prashant Kumar's case, my lord, which is item 16 today, at page 47, your lordship will find my appointment was stayed. Now, my lord, at page 49, on the following date, my lord, this aspect of the matter was brought to the notice of the court that this particular candidate has already served 1 year of service. And perhaps taking note of that, the interim was not extended. And amidst all this, my lord, the IOCL chose to terminate not just Pranav Pathak, but also 5 others. Now, my lord, if your lordship takes up the stand in the affidavit in opposition, my lord.
Okay.
If your lordship may take up page 62 onwards, my lord, that's part of their affidavit in opposition, my lord. So, like my learned senior friend had already indicated, my lord, a complaint was preferred by 62. Now, IOCL says that this is the follow-up action in respect of that complaint by Prashant Kumar. Page 62, my lord. On 28/2/2022, a letter bearing was issued by Vigilance Department to Prashant requesting to verify the ownership of the first complaint dated 22/2/22. That on 7/3/22, a letter was issued by Prashant to Vigilance Department confirming the ownership of the first complaint that the instant letter was received by the vigilance department on so and so. Paragraph Q is important, that on 25/3/22, a case bearing reference number so and so was registered for an internal investigation by the Vigilance Corporate Office, and the Vigilance Department GR was advised to carry out an investigation in relation to the entire recruitment process. Be it stated that the same was an internal investigation in the nature of a preliminary inquiry to arrive at a prima facie satisfaction with regard to the allegations pertaining to the recruitment process. During the investigation, it was observed that the petitioner secured 73 marks in the written examination, and the other candidates, namely so and so, had secured 79 and 93 marks.
So here is why Mr. Patwari is so aggressive.
Yes, Madam.
Okay. Now we got your point.
Now, intriguing. Now, if I may just complete the paragraph. However, the said candidates, namely Prashant and Mr. Rahul, were not called for SPPT test due to overage, although they were entitled to relaxation of age for another 2 years on account of boiler apprenticeship training in terms of clause G7 and G8 of the advertisement dated so and so. As such, the allegations contained in the complaint letter dated so and so, submitted by Prashant Kumar, was prima facie found to be valid. And based on such observations, it was concluded that the rejection of Mr. Prashant and Rahul Das was erroneous, and consequently the selection and appointment of the petitioner against the vacancy available on for OBC NCL was also prima facie found to be erroneous. Now they have craved leave. Now this, my lord, intriguingly, this stand of the IOCL is quite contrary to the stand that they had taken in the writ petitions initially filed by Prashant and Rahul. I'd annex that affidavit.
Let's finish up with this.
Now, my lord,
this is the only allegation against you, or there are further allegations? No.
my
This is
lord,
the only one.
This is the only one.
In fact, this is not even an allegation.
This is a finding.
What had happened was, they are never saying that he has been illegally appointed or something. They are saying that our ouster was not
Wrong.
in accordance with law.
Okay, fine. And they are also, this, everything is in respect of that PNU.
Yes.
PNU. How many posts?
PNU, there are 3 posts, 1 OBC, for which the fight is all about.
And they are, you are also OBCs?
Yes, sir.
Both are OBCs.
So if your lordship allows us to proceed, either of these two, if they don't score more than Pranab Pathak, either of these two are likely to get
in. Okay, fine.
My lord, I must clarify, my lord, so far as item 14 is concerned, we are not going into that question whether age relaxation was available to them. We are assailing the order of termination on the ground of natural justice alone, because your lordship has seen. So I'll
Proceed.
that.
So this is 73, 79 at the initial process of recruitment.
Right.
Their ouster,
Right.
your continuance
Yes.
was held by the IOCL authorities in terms of whatever inquiry they made
Yes.
to be not proper,
Yes.
and accordingly you were terminated.
Termination. Now, my lord, however, their initial stand was of course different. They said that they were not entitled to age relaxation. However, they filed 2 inconsistent contradictory affidavits during the course, when they later on said, yes, it was our mistake. They were actually entitled to.
Okay, fine. We will see. Then what happened?
Now, my lord, page 70, just to indicate their difference in
70.
72, my lord.
72.
Internal investigation in the nature of a preliminary inquiry, and therefore not affording us that opportunity to respond. Well, that based on the internal investigation, I'm reading para W, Manoj. Based on the internal investigation conducted by Vigilance Department, Guwahati Refinery, which was in the nature of a preliminary inquiry, since the petitioner was still on probation, it was decided not to retain him or confirm him in service, instead to terminate his services. Accordingly, on 17/2/23, a termination letter bearing so-and-so was issued by the respondent corporation, who was under probation, that is probationary service was not confirmed by the respondent corporation. Now, this is not in sync with the language of the termination order itself.
Mr. Chaudhary, was there some haste on your part in terminating his services?
I'm sorry, Madam.
Was there some haste on your part made in terminating his services when the issue with regard to their ouster from this election process was sub judice before this court.
But
And a
there-
decision was not arrived at.
there was no interim order. And what had happened was, by virtue of the complaints lodged, an investigative process
Okay, fine.
was
You came to a conclusion that these two persons were ousted, not in a manner known to law. They have been deprived. But the petitioner was not at fault. Pranab Pathak was not at fault at that point of time for his recruitment because it was done in the manner it was followed. Now these two come up before this court.
they had come up long before, when
Long
the
before.
investigation process was going on.
And their appointments had already taken place and it was continuing. These two were before us and we were called upon to examine the matter whether they should be now permitted to take part in the inquiry. Now, before that decision was taken, what prompted the IOCL authorities to proceed to terminate their services? And if you have done so, why was the consequential decision to allow them to participate not taken?
That there is, to some extent, there is interim order.
Subject to outcome of the,
No,
that is,
no, there is. There is an interim order dated 1/3/23
in their,
in Pranab Pathak's case.
okay.
This was the only prohibition. So therefore, in spite of terminating, we did not take further steps. Last but one paragraph. However, as an ad interim measure, it is hereby provided that the post held by the petitioner shall not be filled up without obtaining.
No, this things happened in 23,
Well,
right? Whereas you terminated the petitioner, the final decision was taken as of 17/2/23. Process started thereof before. But when you had reached that decision of 17/2/23, the writ petitions were pending? Were pending?
Yes.
This court did not interfere with his appointments. What made you to take that jump at that stage?
Because your lordship will kindly appreciate. Once the matter
This is a 1/3/23 is a consequence of your action. I'm on your action.
Yes. Action, what had happened was, the CVC made very categorical recommendations. CVC said that you take action against the officers involved, which we have done, in fact.
Major penalty, something has been done against you.
And we have in the meantime completed the proceedings. Proceedings have been completed and penalties have been imposed also. And the second recommendation was, you proceed in accordance with law, so far as the candidates in respect of whom erroneous appointments were issued.
Nothing
So now-
to do with their satisfactory or unsatisfactory
No,
service here.
No. So
now, if this is the circumstance, Mr. Chaudhary, just to understand, if this is a circumstance wherein he is ignorant of everything, he does not know. He can take that plea till he received this termination order. He was not knowing what was going on. He need not know because you made a preliminary inquiry and basing on that, you terminated his services. Now, what was he not entitled in the facts involved? Because it not being a termination per se pertaining to his satisfactory or unsatisfactory service, but for something which he had no role to play.
On these two aspects, I will place judgments. In fact, there are two judgments your lordship is aware.
No, fine. We'll come to that. So this is one area.
Yes.
So the haste, why this haste?
I would not call it haste insofar as, this is not the only, Pranab Pathak is not the only post in question.
No, we are with Pranab Pathak now.
With respect to the others,
there may be some other factors involved. We will examine that. What with Pranab Pathak, it is only 73 and their exclusion from the fray. Because another factor, this was just the entry level of your selection process, right? There were other stages wherein also marks were there. Now,
so that is why I said,
how can you presume How can you presume? And one thing, why did you not come up before this court before terminating their services with a proposal that, see, this is a mistake we made, so we would like to rectify it, and we would like to proceed, have a re-selection for this post from the stage, from the initial stage.
In fact, that liberty has been granted to us. There is an order.
In their petitions.
We have been granted the liberty to proceed, but not to finalize.
And if that be so, when was that liberty granted to you?
Subsequently, obviously. This is an order passed on 30th of April 2024.
In Pranab Pathak's case?
In the entire batch.
30 April.
Yes.
Okay. For all the posts wherein you have made those interferences with the appointments. And have you done it?
We have not.
Okay, fine. So,
In
Mr.
fact,
Dekar,
showing due deference to this honorable court, we thought that since it is now at the final stages.
fine, we got you. Mr. Dekar, so this is your point. Your basically case is, if I've understood you correctly, I had made my candidature. You considered my candidature. You gave me an appointment. I joined. I was working. Nothing with regard to the manner of my working, that it being unsatisfactory. So, if it is for reasons which I am not at all involved, at least it was required that a notice is issued to me. This much only?
This one.
Any decisions you want to rely
My
on?
lord, before that, my lord, if I may just point out, my lord, your lordship had just queried whether they had sought leave of the court in Prashant and Rahul Dasa's matter to terminate my. My lord, on the contrary, my lord, page 113, if your lordship sees. They were contesting their claim of.
Where do I get it?
Page
113 is the starting of an affidavit.
Yes.
Where is the relevant portion?
Page 114 onwards, my lord, para 4 onward. What is the?
Can you give me the date of filing of this affidavit?
5/6/23. 5/6/23. My lord, the affidavit filed by them, my lord, this is
22.
20.
Okay, fine. Then what happened?
Page 114, my lord. This is their initial stand to the claim of Prashant and Rahul that they were entitled to age relaxation and they were illegally deprived, my lord.
Yes.
Para 4, my lord, that the statements made in para 3, 4, 5 of the writ petition being matters of record of the case, the answering respondents do not admit statements made therein which are contrary to or inconsistent with what appears from the record. However, it is stated herein that the petitioner was overage, as according to matriculation certificate, his date of birth was so and so. That is, at the time of applying for the post, the petitioner was 29 years, 7 months, 12 days, and hence not eligible for the post of junior engineer as the maximum age was 26. Under clause G of the advertisement, the age limitation relaxation was categorically mentioned and noteworthy clauses are mentioned below. Minimum 18 years and maximum age shall be 26 years for general candidates as on so and so. Clause G3, relaxation in age up to 5 years for SC, ST and 3 years for OBC, NCL candidates considered against reserved positions will be allowed. Clause G10, maximum relaxation of 1 year in age will be given to candidates possessing boiler competency certificate and being considered for the postcode 202. In the above clauses, it is mentioned that a candidate applying for any post shall be maximum 26 years of age as on 39/21. If any candidate is above 26 years as on the cutoff date, his application will not be considered as he will be overage for the post applied. As per the above mentioned clauses, a candidate may be allowed age relaxation against his reservation as mentioned under clause G3 or may be allowed for age relaxation as mentioned under G10 of the advertisement, but not both. It is to be noted that all the age limitation relaxation mentioned in clause G of the advertisement cannot be clubbed while providing benefit to any applicant under this clause unless specifically and clearly mentioned in the advertisement. Now, this was they were contesting the matter tooth and nail. This was their categoric stand, my lord. All of a sudden, they make a volte-face and they side with the writ petitioners and say, actually, you were right, we were wrong. And therefore they decide to sort of terminate me without even a notice. My lord.
So your case is that as per their first stand, it can be either G3 or G10.
Yes.
It cannot be both.
Yes.
Even if you apply G3 independently and G10 independently, they don't come in.
Yes.
3 years given, they'll be still 9 months, something odd.
Correct.
And G10, 1 year. But now I think they say
You
that
can club all of that together.
G3 and
Cumulative
G1,
relaxation.
it
You
may
can-
not be wrong.
But that's a
It's not wrong.
Yeah, may not be wrong. It
It's
could
not
be right
wrong
either way,
because
my lord,
both operate in different fields.
but true, my lord. Well, I'm
An
not.
OBC, by right, he gets that 3 years.
Right.
But a OBC having a
Competency.
competency certificate, can
Yes.
he be denied that?
No, that is of course a matter of interpretation. I'm not supporting
Okay, fine,
either of the.
fine,
but
fine.
The fact
So
of the
this is
matter
basically the
yes.
ground. Okay, then what happened? Where is
Then-
the change in this ground?
No, my lord.
Where is that change made?
May I point out
Do
my lord,
this.
one factual aspect? Sorry to interrupt. This is an affidavit which was filed prior to the investigation having got initiated. In fact, during the investigation, this stand of the IOC was found to be what was found to be erroneous.
It seems
So
to be.
that is why the contradiction in the stand.
It seems to be. Seems to be. Because
And
you
that is
cannot
why
deny.
directions were issued by the CBC to initiate proceedings against
We'll
the
come to
officer.
that. We'll come to. And Mr. Deka,
Well,
where is the contrary stand to this?
My lord, I have referred to the page 62 perhaps. My lord, page 63, yes,
Of your writ petition?
of the affidavit in opposition filed in this case.
63, okay.
Page 64 would be the relevant portion, my lord. So and so were not called for SPPT test due to overage, although they were entitled to a relaxation of age for another 2 years on account of boiler competency apprenticeship training in terms of G7 and G8 of the advertisement. As
Let's
that-
have G7 and G8.
Page 20. My lord, another aspect, my lord, in that same writ petition of Prashant and Rahul, my lord, the same deponent, after terminating me, files again another affidavit, which is available in 1373, where again he supports the case, and now he says that since we've terminated, the writ petitions have become infructuous. We were initially wrong.
Okay. So basically, what I've understood is that the interpretation of G, clause G, and its various facets is what is to be done in case of Rahul and Prashant. If we come to the conclusion that, okay, they are entitled to an amalgamated relaxation of the clauses, then they come in. If you can show that no, if you give them one, they will not get the next as propounded in the first affidavit, then everything
That
falls in
apart,
place.
my lord, that apart, my lord, if those writ petitions are allowed, my lord, my appointment itself goes, so therefore termination becomes academic. Now, my lord, here insofar, because we are not just dealing with Pranab Pathak, my lord, there are 6 others, my lord. Now, what happens here is, my lord, they have sought to project that this is actually not a termination. This is rather a non-confirmation of your probation. That is how,
I think we have asked Mr.
that is how they want to
Ask
read
Mr. Chaudhary
Right.
he'll have to satisfy this court
Right.
on that.
Right. Now,
But prima facie, it's clause G that will have to hold.
Fine.
Now, do you have any decisions on of the
well,
apex?
but I must clarify, Manoj, for 14 and 15, my friend appears for Pranav Prathap. So,
No,
and then, Manoj, if I may just take your lordship to page 93, Manoj,
Hmm.
that they say is the genesis of it all.
Hmm.
93 is the complaint by Prashant where he alleges anomalies insofar as selection of Pranav Pathak is concerned.
Hmm.
Now, if this is the root, Manoj, then what prompted them to sort of terminate the remaining 6 others, Manoj? This is concerning only with age relaxation, Manoj.
Okay.
Now, Manoj, will kindly for a moment take up that next item of 16, Manoj.
So Pranab Pathak, this is what you have.
I'll then collectively address on the law point, Manoj.
Item number?
17, Manoj.
17.
It's because duty does.
My lord, can I be excused for just?
Yeah, please. Hmm. Yes.
Now, in that writ petition, if your lordship takes up 37, my lord, that's the termination again.
Hmm.
Page 37, my lord. Again, they're referring to the complaint of Prashant Kishore, which is confined only to age relaxation.
No, I
And
got
then
it.
they go move on. to
I
the-
got it. Maybe that will not be much material because after getting that complaint, they proceeded for an inquiry.
No.
And in that inquiry,
My lord, in that
you know the
inquiry,
story of Keshu and Khap.
my lord.
That happened.
But then they should not have been looking for cases
That
at all,
we
my lord.
cannot prevent.
Now, Lord, 3 again, para 3, this is concerning again a manipulation. They are saying this is concerning a manipulation of OMR marks in the OMR sheet. Here also, they don't feel the necessity to put at least the candidate in question who's already rendered 1 year of service to notice.
Now, what is the stand in their affidavit here?
Malod, same stand, Malod, they want to, though it is styled as a termination, they want to say that it is actually a non-confirmation of probation rather than termination. Malod.
No, I'm not on that. With regard to the factum alleged against you.
The OMR, Malod,
OMR.
that if your lordship takes up at page 50. Paragraph P, Malod.
I've got it. Page 51, it's there.
Page 51. It was observed that the name of the petitioner was added in the merit list by manipulating his marks, as well as marks of unselected candidates. So this is again a new ground.
And Mr. Decca,
Yes.
when you're making the submissions, although the matter is pending before the division bench, that APSC selection matters.
Yes.
Although it was on the police report,
My lord.
but the
So,
same
I
very
was
questions,
expecting
unfortunately,
that-
I argued
My lord.
that a notice was required to be given. because of the nature of allegations level. And I relied on certain, Mr. Chaudhary also had made some say and relied on certain judgments. But this court, coordinate bench rejected our arguments.
Rejected. This is the entire subject is new to me. But when I was checking that order, my lord, it appears that there were categorical observations that this is a case where so many materials have been placed before us.
No, that was on the police report. There is one line, another line there, wherein it was said that this matters pertaining to issues, with the issues being pertaining to pre-recruitment stage.
My lord.
Once having been recruited and coming under the rules, whether those could have been utilized, that was also gone into. You just
Yes, yes.
make your submissions also noting that. Because Mr. Chaudhary would be relying.
Yes.
Madam, one thing. As regards item number 70, I'm just trying to formulate my thought process. This upgradation of marks was done by someone in charge of the scrutiny process, who is an employee of yours, not the petitioner. He is a beneficiary. What was the steps taken against that person, connection with this? Can you connect that?
The officer of the corporation, your lordship, charge sheeted and punishment given.
Is there a specific charge made against him pertaining to the upgradation of marks with regard to Bishwajyoti Das in the charge sheet?
Lordship, we don't have the charge sheet copies.
Because now say these aspects are connected. We'll have to look into both. The allegation that you are leveling against the petitioner also has got a nexus with some of your employees. So how have you dealt with that? So I would like to have a link. Because see, if it is a situation wherein no allegation pertaining to Bishwajit Das against that employee concerned who was doing this or whom you suspect to have done it, nothing is there. So how will you sustain that allegation without having that verified from that?
Charge sheet.
You just have there are around how many petitioners? 7?
7.
Leaving Pranab Pathak, that issue is not there. That issue in Pranab Pathak will not come. But in the other cases, wherever such issues are there, wherein there is a manipulation of marks, Mr. Chaudhary, Pranab Pathak is a different aspect, different issues. When we come to Bishwajit Das, we find that the allegation is, I was just referring to our case in that APSC matter, Justice Manojit Bhuya's judgment, wherein also an issue whether the manipulations, things done prior to that recruitment process can be brought in for the purpose of terminating the employee. The court went against the petitioners and held that it can. So now here, the allegation is that he had got some marks, 63, cutoff was 64. His marks were upgraded by an employee of yours. Now I've asked madam whether that employee was proceeded against. Yes, yes. But was he proceeded against with a specific charge pertaining to Bishwajit Das's manipulation?
Those materials we have not brought under.
Because why I'm saying so, if you have made a general thing, and this may be a human error, there may not be an error also. Then how do you hold him guilty for that?
We are not holding any.
Because say, this manipulation done, he is a beneficiary.
He is a beneficiary.
So, if that be so, because your categorical statement is because of this upgradation done, he came in, otherwise he would not come in. So, somebody had done it, if that is the stand. So, that whoever had done it in the OMR sheet, how did you proceed against that?
That as per this CVC itself, I will place all those materials when I'm addressing your lordship. CVC made very categorical recommendations. Mr. A, B, C, D, E, F, G are the officers who have been found to be responsible for all these things. So kindly proceed in accordance with law against them. And accordingly, we initiated proceedings. Those penalties have been imposed. And so far as these candidates are concerned, they again said that you act in accordance with whatever is permissible in law.
We'll go into that. But kindly,
So far as
just a note will do, madam, that this is the officer. With regard to this petitioner, this was the allegation, and finally, this is the conclusion reached. And I don't want the materials. I only want a statement from you wherein Vishwajit Das upgradation, Mr. X is involved. This is the charge against him, and this is the conclusion, penalty. So we have something to know other than the CVC report that you have also had done an exercise in.
yes,
Because Mr. Chaudhary will remember in the APSC case, the argument of the petitioners were that the Home
these are not
Department
during the period.
did not carry out an individual examination. It did not apply its mind to find out. It only relied on the police report. Anyway, that matter is there. But there are decisions of the Supreme Court wherein it requires that there has to be an application of mind by the employer to the materials brought on record. And this is one way you have applied your mind.
And the other, now more or less the law is quite settled, as your lordship is aware. Now the Supreme Court has made it very clear. Then when there are anomalies at the entry level itself, unless facts speak otherwise, in none of the cases, it has been disputed that there is any factual error in this.
That's what I want to confirm. That forget the petitioner being involved.
We are
But
not even remotely.
forget the petitioner being involved. Whether this 63 was actually upgraded,
That findings are there.
that has to be.
Those findings are very clear. We
That
have not.
has to-
It's a very bulky.
I don't want. I want only a statement to that effect. That much I can rely. I rely on
In
you.
fact, as I was pointing out,
Because I want to draw a satisfaction that, yes, this allegation that you have drawn is not a mere allegation made in the affidavit, but supported by contemporaneous records.
yes, it's the CVC when it went into the issue.
In addition to the CVC, I would like to know the
Yes.
manner in which you did it.
Yes, when we
Yes.
proceeded on
So
that basis only.
in item number 17, because Jyoti Das, it is 63 to this OMR tampering. What is your case would be, I don't know.
I don't know, and I should have at least been
Told about this.
Now 17 to 20 is the same. 21 again, there's another ground.
17 to 20 is
OMR.
OMR.
And 21 says that my experience certificate was not right. 21.
IOCL, these issues are very rare.
Very
Otherwise. Yes, what is the
Item
ground here?
Item 21, page 46 is the term. It is paragraph 3, my lord, that it has been revealed that you have appeared in SPPT without experience certificate and the document was submitted after cutoff date. Further, you have submitted 2 experience certificate with different designations from the same employer, which are contradictory and ambiguous. So
Show me the necessity in this connection in the advertisement. Which is the post involved?
this is fire and safety. Is at page 19, Manoj.
7.
7.
Okay, what is the requirement?
Minimum 1 year of post-qualification experience in fire and safety setup involving handling of firefighting equipment, fire water networks, related communication systems, emergency handling, firefighting operations of fire tenders, pump house, etc., in a petroleum refinery, petrochemical, heavy chemical, gas processing industry, fertilizers, power plants, large industrial establishments.
So where is that necessity of submitting the certificate along with the application?
The cutoff date has been given. Twenty-four, 10/21. Page 24.
Cutoff date for this 2021.
At page 23, your lordship will see
5 and 5.
right up before 6.
So that certificate has to accompany your application. You had not given it.
They say I had given it.
No, what is your stand?
I have said I've given it at.
Where is it?
My lord, in fact, I have annexed the documents. Page 45 is the certificate, my lord. Page 45 is that certificate. They say it reached their office beyond the cutoff date. But this is a purely factual aspect which again required some inquiry in my presence.
This is a certificate dated 21/9.
21/9. I was supposed to submit by 24/10. Now, whether I actually submitted or whether the contention is right that my certificate came later, my lord, is again subject to scrutiny and inquiry, for which I had to be put to a.
No, what is your statement in your writ petition to this in this connection? So this is again another aspect. This is the only allegation against you.
Yes. Now, my lord,
So the requirement was for a period of 1 year.
one.
So if we hold this certificate on its face value, you've had that experience, right? Now show me the statement in the writ petition.
Yes, page 8 onwards. He was called for questioning once, my lord. He's the only candidate who was called for a questioning, my lord. And thereafter, my lord, they also sought clarification from the employer concerned, and they also certified, my lord. But then all of a sudden, my lord, the termination followed.
No, your statement that this certificate had accompanied your application either by way of post or on the mail or on online. Where is that statement? Because the allegation against you that this was not received by them before the cutoff date,
Yes.
right?
Yes. That, my lord, has not.
Then that other statements that you have made would fall in place. That the employer also certifying that this is a genuine certificate and all. But the question is whether this reached the authorities. So what is their stand? Their stand is?
Their stand, your lordship finds at page 76. Your lordship seen, my lord, they say, my lord,
77 second paragraph.
77 second paragraph.
Oh, why? What is your response to this second paragraph of
Page
7?
108. I say, my lord, the job profile of a fireman and a supervisor are one and the same.
100 and
108, my lord, para 5.
para?
Para 5.
I'm not on that. This is not the answer. What I'm on is did you submit it?
Submit a revise?
No. Submit that certificate within the time frame prescribed. Because their statement is that at the time of your written examination, which is also a date when you can submit the papers, you submitted a certificate which was not confirming.
And then I submitted a
Then a revised one.
revised certificate.
So if that be so, how do you come out of the allegation?
Well, that is a question probably I would have and could have answered if they would have put me to notice.
They have now filed an affidavit. You have an opportunity to file a rejoined reply.
In my reply,
Why have you not dealt with it?
reply, my lord, if not
Because forget the other cosmetics. Scratch it out. The factum against you is that you have not complied with N5. Right? Simple. You have not given us a certificate. So we can catch them, provided you come up and say, no. The certificate which is there, annexed in the writ petition, was forwarded by me along with the application. Subsequently, maybe I have given another certificate. It's inconsequential because my first certificate is enough. Now, you are posed with a position in paragraph, that second part of that paragraph,
page 70.
70, wherein they say, see, your certificate, first certificate was not proper, but we permitted you to take part in SPPT. That cannot be held against you. And the second certificate and the first certificate is contrary, but still we permitted you. However,
so, Mano, that I had submitted.
Because the authority who permitted you does not have the power of relaxing. Relaxation would again be by the top level. So power of relaxation has not been invoked, neither argued by you. So how do you dispute this factum of allegation?
At least they're not saying that I submitted after. They say, my lord, I had submitted a certificate, but that was subsequently.
No, I'll have to understand that in the light of your certificate at page 45. Because that is the certificate in the writ petition. You said you have satisfied.
Yes.
What is this annexure? Page 45 is annexure 10.
Yes. Page 45 is annexure 9, my lord. This is the part of that clarification by the employer himself. Page 44, if your lordship sees.
No, this certificate that is there,
yes,
they are just confirming that certificate. That means this certificate is the certificate you submitted before the authorities,
Yes, sir.
right?
Yes.
And now, where is that material or the statement to show that, yes, this is the certificate which I had? Or where is the letter issued to your employer?
Page 43, man. But here your lordship will find that this certificate was of supervisor. And this certificate admittedly I submitted on time.
That is what I'm asking you. Where is that material?
There's an admission in page 77. They themselves say.
No. They say that the certificate that you submitted, this is a certificate which conforms
Correct.
to the requirements of N5.
No, it doesn't. Well, because it doesn't say fireman. That is what they found fault with that. They say that this certificate which you had otherwise submitted on time says that you acted as a supervisor. Then they say that I have submitted a revised certificate as a fireman. But strangely, when they had inquired with the employer.
Okay,
they-
come back to page 43.
43. My lord, experience certificate issued in the name of Anshuman Borua, worked as fireman in your organization from so-and-so, issued by the authorized engineer of so-and-so, by serial number so-and-so on 21/9/2020.
So, this is not the certificate which you gave and within the time frame prescribed.
This is the certificate which I gave within the time. Now this difference.
No,
between
that is what I'm saying. You come down to page 44.
Yes, sir. This is the same date, my lord, 21/9/2020.
Okay.
Now,
But-
fireman and supervisor were not an issue earlier.
No,
my lord.
where is the statement that the certificate that you had given is actually serial number 1?
No, para 8 at page 10. No? Confirming the genuineness of the certificate so submitted by the petitioner.
No, I'm not on that. Page 43,
My lord.
there are 3 certificates, right?
Yes, my lord.
Or 2 certificates and an appointment letter.
Yes.
So, sorry, serial number 2,
Is supervisor.
supervisor, which you say you submitted on the date of the interview.
And they also say.
They also say, which they say was not conforming to our requirements.
Requirement of fireman.
So, the certificate that you submitted was
paid.
serial number 2,
Yes.
right?
Right.
Right?
Yes.
So, that does not conform to 5N, the qualifications.
So
If-
there my reply is, my lord, the profile of a fireman and a supervisor are.
But that is not the stand taken by you before the authorities at that point of time. You procured another certificate of the same day at serial number 1 and you submitted that.
Yes.
Right?
Yes.
So how can you now, if you had stuck to 2, saying that supervisor is written there, fine.
Yes.
But that is enough because I'm doing the work of nature. You get hold of my employer and get your clarifications. But now see, there are 2 certificates.
Right.
And you come down to page 44 now.
He says, my lord, experience a certificate issued in the name of Mr. So-and-so working in our organization.
Now, Mr. Deka,
Yes.
here experience certificate issued in the name of Anshuman Bora, so-and-so worked in our organization is genuine.
Yes.
Right? 2, same as point number 1 above. Further, the issue date was erroneously written in the experience certificate.
Yes.
Now, the issue date is same.
Oh, my lord, perhaps when he signed as 21/7/21.
Forget it.
My
The
lord.
issue date, we'll go by the issue date.
Yes, yes.
We give you that benefit.
My lord.
It is 21/9.
My lord.
So on the same day, I don't find any material on record, recording your projection. That on the same date, there were 2 certificates issued to me.
I have not said. I have not said that. I have said, my lord, my certificate that was received on time.
Because the certificate that you gave, they say it was erroneous. It was not conforming to them.
Yes.
And you have not disputed that.
No, I have said that it is.
No, that is because you say supervisor and fireman is one
Yes, yes, correct.
in that line.
Yes.
But the factum that
That
serial
regard-
number 2 certificate was page 43, serial number 2 was submitted.
Yes.
You don't dispute that.
I have not accepted or denied.
You have not denied that. Now, from where have you got 1? Because you don't make a statement that on the day, I would have understood. On the day, there were 2 certificates given. One as a supervisor, one as a fireman, because both are same.
And I submitted.
I erroneously submitted.
Supervisor.
Then you would have gone out. Anyway, anything more?
My lord, now, my lord, if I've understood the stand correctly, my lord, the stand basically is that this is not a termination, number 1. Number 2.
No, I am with you on that. Subject to what Mr. Chaudhary would satisfy me, I am with you on that. I am with you on that. But that is for Pranab Pathak.
Yes.
Now, OMR will have a different connotation.
Yes.
Because there is, you may not know. You can take a plea, I don't know. But you are a beneficiary. What made them to do that? If not to benefit you. So for that, I'll have to see how they have dealt with their
There's
authorities.
hardly any material, my lord. If I may just point out, they have created leave in the affidavit in opposition for 5 vital documents, including the charge sheet, my lord, investigation report.
That is what I'm requiring them to produce now. And I don't want the documents. I want the statements that Mr. X relating to Biswajit Das or Pranab Pathak, whoever it is. This is the allegation. This is the inquiry finding, and this is the penalty. So that will show that there is a nexus between the employee and the candidate, just to establish that. But here, in this case, it's for you to establish.
My lord, if they show all those materials, my lord.
They need not. In this case that I am holding,
Yes. Anshuman.
Anshuman,
Yes.
you have not developed your matter in that line. Where are they called upon to reply? They said the certificate he gave at the first stage was not proper, but we allowed him.
And
second certificate given also contrary to the first one, but we allowed him. You can develop an argument that once you have permitted me to go in and I having something, you should not have come back and said that those are not proper. That argument is also not forthcoming.
I've said that.
That argument is also not forthcoming. So you must give some material requiring Mr. Chaudhary to argue. Otherwise, he will stick to that second paragraph and say that's the end of the matter.
Well, if that is the case also, my lord, naturally they must have done an inquiry, my lord.
We'll have that. We'll have that. But I want you to first open up.
My lord, I'd say.
Got it. Anything more?
Coming to the law.
I'm not concluding. I'm getting the feel only. Don't worry.
Lord, insofar as the law is concerned, my lord, if I have understood it correctly, my lord, first there is the form test, and your lordship will see from the order itself whether it is stigmatic or whether it is punitive in nature. Now, if we do a thorough reading of the termination orders, my lord, 2 things are apparent, my lord. First, they have done an inquiry. Now, they call it a preliminary investigation. I call it an inquiry to find out guilt, my lord. Secondly, my lord, they have also said that I have, they've though not said in so many words, they've indicated that we are a public sector undertaking, taking amenable to Article 12, etc., and therefore we should not let all of this happen. Now, my lord,
that is an argument of yours on the on the effect of
Effect.
the impugned action
Right.
on your services.
Yeah.
What I am considering now is the factum of the allegation made against you. First, whether that was made with some materials on record.
My lord,
So, Pranab Pathak, it has a relationship with them. The next few cases is OMR, for which they'll have to show how it was done. But in the last case, the onus is on you.
my lord, I'd like to put it this way, my lord, material or no material, my lord.
Because why I'm saying so? If you have not acted in the manner required to be acted upon, and somebody facilitated, opened the door for you, you have blocked another genuine candidate from coming in. So we'll also have to keep that in mind.
Definitely.
I'll give you the longest rope I can. But at the end of the day, if I'm not satisfied that you have acted bona fide, at least in the last case,
Lord, I would say that in
I
general.
will hold that your recruitment being, there are decisions, Mr. Chaudhary will naturally place those. Your recruitment being not in the manner required in the advertisement or the rules, whether you have continued for a year, whether you have continued for 2 years, will not make a difference. And an inquiry may not be called on. If the factum of the matter is through, it would be just an empty formality. Aligarh.
Aligarh is there. There are subsequent judgments also.
I've understood.
Work on it. I'm not blocking you. I'm not blocking you. I like the way you presented the matter in a service law. It's really appreciable, but develop on that. We'll not give Mr. Chaudhary an easy walk. Over. So, I know he is armed with those things. Having seen him practice for such a long time, I know what he is coming up with. He'll hit you there. Try to get out. Because I want to, if I come against you also, I want you to be satisfied that you have done your bit. But I am not very sanguine in the last case.
That, of course, I'll try, my lord. My lord, one thing, my lord, if I've understood the defense correctly, my lord, the IOCL would definitely want to go into that distinction of foundation and motive.
We will not allow them to go into that. I will only examine the factum of the allegation. And if I find that the factum of the allegation is correct, established, then the next question would be whether a notice to you was required. I'll permit you to argue on that. Right? Thereafter, I'll take my call. Right? Yes, Mr. Chaudhary.
So should I address or should I first produce the record?
You have to produce that. I want that. Now we have understood.
Yes.
The counters.
So
what I advise,
your lordship wants the proceedings that we initiated against.
Not in Pranab Pathak, in the other matters.
Yes.
Where the OMR is in question, how you have alleged any misconduct in regard to the person who was doing that. Right? One. In the last exercise, I want a little bit more clarification because your affidavit says that the certificate he gave, you accepted, you permitted.
Provision.
You accept. No, there has to be something there.
I will point out straight away.
There should be something there.
In fact, we were giving him the all possible benefits that we possibly could have given. But when we found that he produces a certificate of the same day,
that is
with a different
what I was asking him.
And in fact, that is what it says. In fact, that letter at page 43 that we wrote to his employer. That's not suspicion. And if your lordship will come to the advertisement, if your lordship is holding Anshuman's case.
Anshuman case. Advertisement, anything, anywhere I'll get it. No problem. You go ahead. A clause, just tell me the clause N. 5N. N5.
N5 and then small Roman 6. Experience certificate or copy of the offer letter joining, etc., etc., proving the continuance of experience for the period being claimed The documents submitted in support of the experience must clearly establish the period of experience as well as the nature of relevant prescribed experience being claimed against the post applied. So this is the moment he produced 2 certificates of the same day.
Supervisor and fireman.
Fireman. Which one? How do we believe?
That is why I asked him
And he
whether
has
it,
not, as has rightly fallen from your lordship. In that angle, he has not developed his case at all. There are no pleadings at all.
we'll give Mr. Decca a longer rope.
And
But
he deserves it.
he
right?
deserves
As a branching out from civil to service law.
Yeah, he deserves it.
Making things difficult
Really
for us
impressive.
now.
I'm impressed. I'm impressed. Feels like my days then. Anyway, sorry if I have gone into the facts of the matter. Just to satisfy myself, I've gone into. So when can you give me?
The lordship will fix it on 8th. It's a hearing day.
But
By then,
give me a day before these materials. And both of you, don't give me a written argument today. If any decisions you want to rely upon, at least the citations will do.
Right.
If you can give me a day before, so that I can also come up. And now coming to the 2 smiling people there, Mr. Patwari, and we will have to have a clarification from you. Given the stand pointed out in the first affidavit, whether the different categories of relaxation given can be given as a sum total,
that has
or
been answered.
it's exclusive. Why I'm telling you, there is a decision in where I appeared other side before Calcutta, before your Shillong bench, Meghalaya, wherein the same thing I had argued, citing yesterday I was searching for that judgment, I could not get it. Citing a Supreme Court judgment, this prayer was rejected.
The Supreme Court has accepted.
It's there. Place that decision
Why
also.
not?
It will be
That's why, my lord.
2+3. Supreme Court has said 2+3. Our High Court, my Lord Justice Ujjwal Bhuiya's judgment, there is a judgment where a specific stand was taken. In fact, my Lord, the affidavit, first affidavit that was pointed out by my learned friend, Mr. Decca, that the error that was detected during the inquiry, that it could not have been
No,
just
my
one.
Lord Justice Bhuiya of our court
My Lord
said
Justice
it could
Ujjwal
be
Bhuiya
exclusive to each other.
plus 2+3.
My Lord had 2+3.
Yes.
That has been upheld by the Supreme Court.
No. Supreme Court judgment is in a different case altogether.
What does the Supreme Court judge?
Supreme Court says they will be entitled to the benefit, added benefit of experience. I think my friend is ready.
Just show me.
By the 95 PS.
My
My lord, that's why, my lord, the facts has to be pledged in.
Understood. If I had permitted you today, because I hear you daily, I have heard Mr. Decca.
They have mentioned about the affidavit in opposition, but not mentioned about our reply, wherein these 2 judgments are mentioned, my lord.
Which paragraph?
Paragraph 12, my lord. In the background of what has been noted above, we state that the following would be kept in mind while dealing with the claim of trainees to get employment after successful completion of their training. Other things being equal, a trained apprentice should be given preference over direct recruits. Also, will kindly come to 3. If age bar would come in the way of the trainee, the same should be relaxed in accordance with what is stated in this regard, if any, in the service rule concerned. If the service rule be silent on this respect, relaxation to the extent of period for which the apprentice had gone training would be given.
No, I'm not on that. For that portion, you get a mark. That is no doubt on
Yes,
that.
now, Lordship.
No, relaxation.
Relaxation you get. There is no doubt.
Yes, I'm coming to.
But whether that OBC will also now,
Kindly take our reply. They have annexed the order of Justice that my learned senior.
which is that citation, just give me a
It's
citation.
not reported.
It's not a reported
reported.
judgment. They have annexed it.
You have in Pranab Pathak's
No,
case.
no. But we are not even a party.
Which case have you annexed?
Item number 15, man.
50.
Rahul Das.
Not reduction. Wherein it is held by this court that it will be 2+3.
Yes.
And in fact, that is another aspect which your lordship will have to consider. In Pranab Pathak, he has consciously decided not to make Rahul Das and Prashanga party, in spite of knowing all this fact.
This reply is not annexed to the writ petition also. Lordship will kindly come to running page 67. Our reply affidavit to the first counter affidavit filed by the IFL. Para 4, we have made the statement, and the annexure, my lord, that order at page 71, annexure M. Lordship will kindly see para 3 also. Page 66, para 3.
No, I just want to see from the judgment.
Yes, judgment is annexed at page 71, annexure M. Lordship will kindly, may I read the relevant portion at page 73. Same issue, same post.
Okay, the decision of the IOCL authorities were upheld.
Yes. How can now they take contradictory stand, my lord?
Okay, fine. Good.
After filing this reply, they are supplementary.
So on the next date, we'll hear you first on the point, and thereafter we'll hear Mr. Chaudhary. Mr. Deka, you develop your legal arguments on that notice issue, because that it will boil down. If we hold that this is also again correct, whether a notice was required to be given. That much only. And on 7th, can you give me those?
I will try. There's something very big coming up at Itanagar on 7th. I'll tell my juniors. Just your lordship wants the.
If you have problem on 8th coming back, then
No, I'll get back. Even if I reach late, I'll do it, because otherwise I'm next week again.
Mr. Chaudhary does not read; he only smells.
I'll tell my juniors. Your lordship wants the citations.
Citations and also those
that charts. My junior will give it. And your lordship is keeping it parted.
For further hearing, heard the Learned Council for the parties at length. List again on 8/8/2024 for further hearing. Just develop your level now, that argument to the next level. We would love to hear you there.
Obliged.
Thank you.
Deeply obliged.
Item 22.
Sorry to keep you waiting, Mr.
No,
Nath.
my lord, it's the daily affairs, my lord.
Anything?
I've gone through it, my lord. I've gone through it, and I found judgment of the apex court exactly on this point, like the merit. My lord, let me give that.
Oh, that is why.
That's for your lordship, my lord. Two dates are important. One is date of divorce decree. 21/2/2014.
21?
2/2014.
Okay.
And second marriage, 26 9/16.
What is that? Marriage, second marriage.
26/9/16.
Okay.
Relevant.
Okay.
I'll just place it, my lord. My lord, what happens, my lord, in this particular case? In this particular case, my lord, ex parte degree of divorce was on 15/12/89. Husband died on 26/5/90. Let me place this one, then I'll take a lordship to paragraph 6. It will be shorter, that's why. Husband died on 26/5/90. Thereafter, 3/7/1990, the wife filed an application under Order 9, Rule 13 to set aside the ex parte order. The trial court dismisses petition. Dismissed the petition. She went to the High Court. She filed a revision petition, which ought to have been fast tracked or something, but that was avoided. She went to the revision petition. In the revision petition, the Honorable High Court set aside that divorce decree, that order, my lord. Remand back the matter to the
family court.
That particular court, my trial court. Now, what the situation? In this situation, the husband since died, mother of the husband, mother of that, she came to the Supreme Court because his son is already dead. Now she has come to Supreme Court because that was set aside clause challenging that High Court's order, my lord. Now the question arose. One of the argument of the appellant, the mother was before the Supreme Court, was that since he has died, no cause of action, there no right to sue. That was her argument, my lord. She said, now the question arose is, when the divorce, my lord, petition is pending, then what happens if the husband dies? Then the apex court in paragraph 6 said, my lord. Paragraph 6. Let us come to paragraph 6 now, my lord. Page number 4. That takes us to the consideration of the alternative contention canvassed by the learned counsel for the appellant. It is true that contention was not canvassed before the trial court or the High Court. However, as this contention touches the maintainability of the application, we have thought it fit to hear the learned counsel on this point. So far from here, my lord. So far as the contention of maintainability of the application of the respondent wife is concerned, it must be kept in view that petition of divorce was moved by the husband for getting his marriage with the respondent dissolved by decree of divorce on the ground that respondent deserted him for a continuous period of less than 2 years immediately preceding the presentation of the petition. To be kept in view that such petition for divorce can be moved either by the husband or the wife, as the case may be. To that extent, it is certainly a personal cause of action based on one or more matrimonial misconducts alleged in the petition against the erring spouse. Consequently, in such proceeding, before any, my lord, this is important. Consequently, in such proceeding, before any decree comes to be passed, if either of the spouse expires pending the trial, then the personal cause of action would die with the person. Next, such civil proceeding would not abate only if right to sue survives after the death of one or more parties to the proceeding as laid down Order 20, Rule 1. Slightly different. Next, however, if during the pendency of the petition of divorce, either of the spouse expire, the cause of action being personal to both of them, the right to sue would not survive. That is, my lord, during the pendency, decree is not passed. Then
what happens?
Yes. Then next, the next question is whether after the decree of divorce is passed ex parte, like our case, or bi parte against the other spouse, whether the right to sue would survive for the spouse against whom such decree has been passed by the court, and whether such a decree can be got set aside by the surviving spouse either by filing an appeal under Section 28 Hindu Marriage Act or by moving an application under Order 9, Rule 13 CPC for getting a set aside if it is an ex parte decree. My lord, answer. The answer to the question will depend upon the legal effects of such a decree of divorce passed by the trial court under Section 13(1) of the Hindu Marriage Act. It is obvious that so long as the decree is not passed and proceedings are at any stage prior to the decree, no right or obligation of either spouse get crystallized.
the marital status of both the spouses remain intact as it was prior to the filing of the suit. Once a decree gets passed in such proceeding, the rights and obligations of the respective spouses who are parties to such proceeding get crystallized under the order of the court. The marriage gets dissolved. The status of the spouse gets changed and they become ex-husband and wife. As a result of such a decree of divorce, the marriage tie is snapped. Both of them become free to marry again as laid down under section 15 of the Hindu Marriage Act. 90 days period, my lord. After every appellate period, they can marry again. Not only that, after such a decree, when the spouse have ceased to be husband and wife and become ex-husband and ex-wife, property rights of both the spouses also get affected. As per section 8 of the Hindu Succession Act, if a male Hindu dies intestate, his widow would be entitled to inherit his property, being a relative specified in class 1 of the schedule. Similarly, if the wife dies leaving behind her property, as per section 15 of the Succession Act, the property of the female Hindu shall devolve according to the rules set out in section 16 firstly, upon the sons and daughters, including children and sons and daughter and the husband. Thus, if a female Hindu dies leaving behind her children and husband, the husband also becomes entitled to inherit her property as first class heir. Consequently, because of divorce decree, when the spouse do not remain husband and wife, the mutual rights of inheritance in each other's property on the death of either of them get extinguished. Therefore, apart from the divorce decree destroying the erstwhile status of husband and wife, it has a direct impact on the proprietary right of the concerned parties. Now kindly see the social stigma about. Even that apart, as per section 9 of the Hindu Adoption and Maintenance Act, a Hindu widow is entitled to be maintained out of a deceased husband's estate, in failing which by her father-in-law under circumstances laid down in said section. Even this right will vanish after the decree of divorce, when her husband dies after obtaining that said decree against her. It has also to be kept in view that when a decree of divorce gets passed against a spouse on the ground of matrimonial misconduct and mentioned under section 13(1) of the Hindu Marriage Act, my lord, desertion and other act, it attaches a social stigma on the concerned spouse. Such spouse cannot be said to be left without any remedy to get such finding vacated by filing an appeal, or if it is an ex parte decree, to get it set aside by filing an application under Order 9 Rule 13 CPC. Cause of action for getting such an adverse finding stigmatizing the concerned spouse cannot be said to be purely a personal cause of action against the departed spouse who was armed with a decree in his or her favor based on such a finding. When such legal effects flow from the divorce decree, it cannot be said with any emphasis that proceeding for setting aside such a decree either by way of appeal or if it is an ex parte decree by way of application under Order 913 would also abate, and such a right to sue for getting the divorce decree set aside by the aggrieved party whose status and proprietary right gets adversely affected by the such decree, who should survive to such an aggrieved spouse. It is also pertinent to note that as per section such as this lotion may skip this part, lotion may come to my lord. Next page paragraph, my lord, page 8.
Paragraph?
Page, please, second paragraph, page 8. Page 8, second paragraph. My lord, let me read
For
here,
coming to the aforesaid conclusion.
Yes. For coming to the aforesaid conclusion, Lordship has got it?
Yes, yes.
The learned judge has relied upon an earlier decision of the division bench of the High Court in the case of such and such, my lord, and the decision of the division bench of the Andhra Pradesh High Court in such. It must therefore, this is important, it must therefore be held that after a decree of divorce is obtained by petitioning husband against his wife, she has right to file an appeal, and such appeal does not abate on the accounts of death of the respondent husband, whether such death takes place prior to filing of the appeal or pending the appeal. Similarly, if an ex parte decree of divorce is obtained against the wife, and thereafter if the husband dies, like our case, the aggrieved wife can maintain an application under Order 9 Rule 13 CPC, even though the husband might have died prior to the moving of that application or during pending of such application, identical case. In all such cases, other legal heirs of the deceased husband can be brought on record as opponents or respondents in such proceedings by the by the aggrieved spouse who wants such decree to be set aside. And when other heirs of the deceased husband would normally be interested in getting such decree confirmed either in appeal or under such and such. Order 9, Rule 13. Second alternative contention is canvassed by the learned counsel for the appeal and therefore stands rejected. He said, my lord, right doesn't survive, my lord. That's what, my lord. Now, lordship, kindly see the paragraph, lordship, I think.
No, it's okay, please.
Last, let us finish, yes. Now 10. In that case, my lord, what happened, concluding part, in that particular case, here. Now remains the question as to whether the proceedings for divorce as restored by the High Court by the impending order and required to be proceeded further, or the curtain must be dropped on the said proceedings. As the ex parte decree is found to be rightly set aside by the High Court, the marriage petition would automatically stand restored to file of the learned trial court judge at the stage prior to that at which they stood when the proceedings got intercepted by the ex parte decree. Once that happens, it becomes obvious that the original petitioner seeking degree of divorce against the wife being no longer available to pursue the proceedings now, the proceedings will certainly assume the character of a personal cause of action for the deceased husband, and there being no decree culminating into any crystallized rights and obligations of either spouse, the said proceeding was obviously stands abated on the ground that right to sue would not survive for the other heirs of the deceased husband to get any decree of divorce against the wife, as the marriage tie has already stood dissolved by the death of the husband. No action therefore survives for the court to snap such a non-existing tie. Otherwise, it would be like trying to slay the slain. At this stage, there remains no marriage to be dissolved by any decree of divorce. Consequently, now that the ex parte decree set aside, no useful purpose will be served by directing the trial court to proceed with the Hindu marriage petition by resorting it to file. The Hindu marriage petition 25 moved by the such and such husband of the respondent on the file of the court civil judge get will be treated to have abated and shall stand disposed in first just.
Beautiful. Thank you.
This
It
is
answers.
exactly, I found, my lord,
No.
answer the lord's query.
No.
Because now two options left. The petition which is pending there. Now, now what has happened? Against that, my lord, pension, the person has come before this court. But what invoked here is Article 226, 27. Number one prayer is, my lord, to give her, the petitioner, the pension. And number two, to stop pension to the second wife. Third, to set aside and quash the, my lord, divorce, that divorce decree, my lord, which probably, my lordship, cannot in this case. Now, the only option left is, my lord, that trial court, where it's pending, that should decide it. And once that is decided,
We'll quote this matter. Mr. Nath, just guide me. We'll quote this order. We will say that the prayer number 3, now it is pending before the trial court.
Yes.
In view of this decision,
exactly,
the trial court is to take the matter to its logical conclusion, pass its judgments thereon. Now, basing on that, if the decree is set aside, ex parte decree is set aside, then the petitioner regains the status of a widow, and accordingly she would be entitled to pension and pensionary benefits, which would then be determined by the respondent authority and paid to. Pending a decision of the trial court in this connection and the further processing, the further release of pension to the second wife, we will restrain.
This is permissible or not? I'm a little doubt I have got here because kindly see, I said the date, first date. See, my lord, on 15/12/89, divorce decree was passed. That's also, I was thinking about that point. 15/12/89, divorce decree was passed. Husband died on 26/5/90, my lord. And he got married. He got, oh my lord, sorry, 21/4/14, divorce decree passed. 26/9/16, second marriage held, my lord, solemnized. Now, if your lordship kindly see them, Hindu Marriage Act. Hindu Marriage Act, my lord, section 15. That's why I'm saying, my lord, dear lordship, will think a little. Divorced persons when may marry again. When a marriage has been dissolved by a degree of divorce, and either there is no right of appeal against the decree, or if there is such a right of appeal, time for appealing has expired without an appeal having presented, or an appeal has been presented but has been dismissed, it's lawful such and such. 90 days time.
So
now,
he has married after 2 years.
Oh, yeah, that's why.
But Mr. Nath, the decree itself was an ex parte decree, right? Because under this ex parte decree or normal decree,
right or wrong,
it is
holding the field.
It is holding the field.
It's holding the field. That's why.
So we cannot interfere with your submission is that we should not make any observation with regard to pension.
Probably I'm not.
And we leave it to the trial court to come to a conclusion first. But we will say one line that in the event the trial court concludes an expertise degree is set aside, she regains the status of a wife,
Yes.
first wife,
Yes,
and then the respondent authorities would be bound to consider her claim for pension.
exactly. That should be better, I think, my lord.
Right.
Because too
Thank
many
you.
would be, I think, my lord,
Too much.
little. That's what I feel, my lord.
Too much. Okay. Done. Thank you.
My lord,
Thanks a
my
lot.
lord. No, it's interesting, my lord.
Very
I
interesting.
learned this part also. And all of my colleagues also, my lord. They were interested.
No. Now you have opened my eyes on this line. That was my doubt.
There's the system we learn, my lord.
No, that
All
was
of
my
us, my
doubt.
lord, will learn, my lord.
I was having it very difficult, finding it very difficult to
Yes. No,
accept the contention that the husband had died in pursuance to
my lord, my these colleagues, my lord, the chamber, lot of discussion last 3-4 days, my lord.
thanks to them. So I was finding it bit difficult to accept that proposition, whether one will be left totally remediless.
And I have given 2 judgments. There is another judgment just below, 1-page judgment.
Huh.
Just kindly have a look. 1 page. That's from 1996. One is 97. 1 page, my lord. Paragraph 3. Paragraph, very small judgment. 2 and 3. Exactly on the line. What I have read just now.
Ah. Same thing.
Same thing, my lord. That's right.
This is from Supreme Court.
So both of them Supreme Court, my lord.
DP Jivan Reddy and the
Yes.
other one is
And
SB Mojumdar.
Yes, my lord.
Legendary figures.
Yes, my lord. Very known.
None is appearing for the petitioner. Huh?
I am for respondent number
3. And second wife.
Probably he thought 1 o'clock. That second other case was
Okay.
probably.
Mr. Nath, you need not be here.
My lord.
We'll call it again at 2. Just inform the council of the
Doesn't matter,
petitioner.
Malu, here, my lord.
No, we'll just close the matter.
My lord,
We'll pass an order and we'll close the matter.
my lord.
But I will go through it once more and then
Yes,
pass
yes.
the
That's
order.
why, my lord, I thought at least chamber lordship will go through it again.
I'll go. Yeah, Monty.
One small submission. For item number 27, we have taken the concern to the other side.
I did not want to, I just wanted a clarification from Mr. Doctor. So that we can do something for you. Okay, fine. On the prayer made on behalf of Mr. P. Mohanto, Learned Counsel appearing for the petitioner, the matter stand adjourned today, registered to list this matter after 4 weeks on a date to be fixed by it. Heard Mr. D. Chakraborty, Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Counsel appearing for the Standing Counsel, Finance Department appearing for the state, for all the responses. Also, the petitioner, by way of instituting the present proceedings, has prayed for a direction upon the respondent authorities for consideration of his case for promotion to the next higher post of financial advisor of the senior finance and accounts officer with effect from 17/10/2013. Also, the petitioner herein, who was recruited as an officer under the Assam Finance Service on 4/12/1978, came to be promoted to the post of, to the cadre of Finance and Accounts Officer of Treasury Officer in the month of September 2003, and thereafter continued to serve in such capacity till the date of his superannuation, that is on 31/5/2015. So the petitioner contends that on completion of the period of residency as mandated under the provisions of the rules holding the field, that is the Assam Finance Service Rules 1963, he was entitled to be so considered for promotion to the next higher grade for the posts available in the next higher grade of Financial Advisor / Senior Finance and Accounts Officer. However, his case was not so considered. So the petitioner submits by referring to the gradation list as published from time to time that he was within the zone of consideration for such promotion. Although there were certain inconsistencies in the assignment of seniority positions to the petitioner in the gradation list published from time to time, however, in the gradation list so published, in the month of April, 22/5, on 22/5/2015, his seniority position has been correctly assigned. So, however, the respondent authorities, in spite of there being vacancies available in the promotional cadre, has not considered his case, and accordingly, he had to retire from his services on 31/5/2015 from the post held by him in the cadre of senior a cadre of finance and accounts officer / treasury officer. Also, accordingly, the present petition has been so instituted, praying for consideration of the case of the petitioner for such promotion with retrospective effect, that is with effect from the year 2013, and for notional fixation of his pay and allowances till the date of his superannuation. Also, subpara. The learned counsel for the petitioner has reiterated the facts as noticed herein above, and has further contended that in spite of repeated representations being submitted by him for having his case considered for promotion to the rank to the cadre of senior financial advisor, / senior finance and accounts officer, the respondent authorities have not considered his case in the manner required. Also, it is the further contention of Mr. D. Chakraborty, learned counsel for the petitioner, that in spite of the fact that he had superannuated from his services, vacancies having arisen in the cadre of in the promotional cadre much before the date of his such superannuation, the case of the petitioner must necessarily be directed to be considered by the respondent authorities for such promotion, inasmuch as consideration for promotion is a fundamental right as vested in the petitioner. Also, per contra, Mr. B. Gogoi has submitted that the process for finalizing the gradation list had taken some time. However, their same was finalized on 22/5/2015, and the process for convening a meeting of the Departmental Promotion Committee was underway, and the collection of the requisite materials in this connection pertaining to the candidates in the zone of consideration was also being carried out by the respondent. However, during the pendency of such process, the petitioner had retired from his services. Also, Mr. Gogoi has further submitted that the number of vacancies as available in the promotional cadre, given the number of vacancies as available in the promotional cadre, the petitioner by way of seniority position as assigned to him in the feeder post would not have had his case, would not have been eligible for such promotion. Also, I have considered the submissions made on behalf of the learned counsel for the parties, and also perused the materials brought on record. Also, it is an admitted position that the petitioner had retired from his services on 31/5/2015, and thereafter had instituted the present proceedings on 1/6/2015. Also, although it is contended that vacancies were so available in the promotional post, the exact number of vacancies have not been disclosed either by the petitioner nor by the respondents hearing. Also, however, it is seen that the process for convening the meeting of the selection committee, which was underway as contended by the respondents in the matter, could not be concluded before the retirement date of superannuation of the petitioner herein. Also, the manner and method for recruitment to the post of promotion to the post of financial advisor, senior finance and accounts officer is governed by the provisions of Assam Finance Service Rules 1963. Also, The post of financial advisor, public senior finance accounts officer is placed in grade 2 of the service, and the promotion thereon is to be so effected from the feeder post of treasury officer and analogous posts. The said rules mandate that the promotions to the various cadres of the service can only be so effected by way of a selection so conducted by a constituted departmental selection committee. Full stop. The issue as arising in the present proceeding is as to whether on a vacancy being available, the case of the petition can be directed to be so considered even after the date of his superannuation. First of all, further, whether the petitioner has a vested right to have his case so considered from the date the vacancy has so arisen in the promotional post, and or whether such promotion can only be deemed from the date of the actual promotion being effected in case of an incumbent in the feeder cadre. So, the Honorable Supreme Court in the case of Union of India versus KK Vadera had clearly laid down that the promotion to a post should only be granted from the date of promotion and not from the date on which such vacancy has arisen. Full stop. The relevant observations of the Honorable Supreme Court in this connection as made in the said judgment is extracted herein below. Para 5 to extract coedible. Full stop. This court, further, the Honorable Supreme Court, in the case of Ajay Kumar Shukla versus Arvind Rai, reported in 2022 bracket of 12 SSC 579, after noticing the judgments in the earlier decisions of the court, proceeded to draw the following conclusions. Para 41, A2, A. Also, accordingly, considering the above noted decisions of the Supreme Court, it is clear that that a government servant cannot aspire to be promoted from the date the vacancy had arisen, and mere existence of a vacancy per se will not create a right in favor of the employee for retrospective promotion when vacancies in the promotional post are specifically prescribed under rules, which also mandate clearance through a selection process. First, having considered the above aspect of the matter, the further issue as to whether the petitioner on his superannuation would still be entitled to have his case considered for promotion to the promotional cadre, post in the promotional cadre, is being considered. Also, the said issue was considered by the Honorable Supreme Court in the decision in the case of Union of India and another versus Manpreet Singh Poonam and others. Manpreet Singh, it was reported in 2022, 6 SSC 105. The Honorable Supreme Court, on examination of the matter, had made the following, had drawn the following conclusions. Para 16. Para 16 to put it here. So, applying the ratio of the decisions in the above noted case of the Honorable Supreme Court to the facts of the present case, it is found that the petitioner herein has no vested right to be so considered from the date the vacancies have so arisen, and the provisions of the rules, that is the Assam Finance Service Rules 1963, governing the promotion to the service wherein the petitioner had figured, having not conceptualized any such promotion to be granted with retrospective effect, that is with effect from the date the vacancy had so arisen, and the promotion therein being so held to be effective from the date the promotions were so granted, comma, this court finds that the claim as made by the petitioner in the present proceedings does not merit any further any consideration. First off, accordingly, the repetition subpara, accordingly, the repetition is held to be devoid of any merit and the same stands dismissed. However, there would be no order as to pass. In
Sorry, my lord.
no, it's okay, Mr. What do you have to say?
My lord, the petitioner has no locus standing to file this case because
Why?
she's outsider.
Now tell me one thing. Whether a village can be a part of the Gaon Panchayat as well as the town committee.
That is a political decision. As
No,
per
no.
political
Whether it can
decision,
be.
She is from Dhing town area.
No. She is in that Niz village. Now that village I find is divided into two parts. One
Yes.
falls under the town committee. That cannot be construed as a village, can it be?
No. It is divided to two parts and my part falls within the center area. Her parts fall into
No, whether
ward
her
number 10.
part will also be a village or it should be considered as a part of the town area.
My lord, my humble submission is this. Why your lordship would not believe the report of the circle officer?
I'm
Deputy
asking you a
Commissioner
question.
and director.
I'm asking you a question.
Yes.
Whether by she figuring in an area covered by the town committee, would she still be deemed to be a member or a resident of that village concerned?
Maybe.
Maybe. Then she has a case.
Sometimes, my lord, the villages are extended or its areas are reduced. So in that view, some areas are included in the town area.
No, once it is included in the town area,
Yes.
whether it will still be a village or a town.
It will be in town area.
That is what I want.
Name is there.
That is what I want.
But advertisement is very much clear.
No, advertisement says
candidate-
village.
Huh?
Village.
No, center.
No, village.
No.
You come to page 19.
No, kindly see page 21 of their petition.
Advertisement says.
21 lordship has
Center
seen.
area.
1.
21. Yes, one is the candidate of the post of Anganwadi worker and Anganwadi helper shall be a local woman residing in the same village where the Anganwadi center is located.
Because Mr. Mahmood, after this, the advertisements that have come after some time,
Hello?
this is of 2007.
Yes.
Subsequent advertisements mandate that it should be within the center area. But this advertisement says it should be in the village. So village, revenue village. So if it is revenue village, she is placed in the revenue village.
Where the
Then-
center is located.
Right, it's located in a village.
Yeah, located in a village.
In a village.
But
So-
that village has two parts. One is in town area, one is in.
So now whether that town area will also be a village, just that clarification I want you as an officer of the
Area
court.
means, my lord,
Outside the,
Bongaigaon, that is a town, big town, but Gowers are there. So Gaon.
no, Gaon will be covered by Bongaigaon Municipal Corporation or by the Panchayat.
Yes, lordship.
That
but
is the-
it is
in
what
board
is
area.
Their lordship, this is under the municipal area.
Yeah.
lordship.
So it is not a village.
No, it's not a village lordship. So when wards are marked lordship.
Yes, she has
There
she has
should
no
be
locus.
name lordship of a particular area.
Hmm?
There should be name of the particular area.
No, whether that area you say you admit you are under the town committee, that cannot be a village.
What number
That is
10?
enough.
Not the town, not by the Gaon Panchayat.
Oh, you are not
Still, name of village is remains.
village, that is for common parlance, but regally that area will not be a village. It will be a town, part of a town.
Town area.
But name of village is remain same.
Lordship.
Yes,
village
Mr.
is
Nath.
their revenue.
Mr. Nath.
Their lordship.
Whether when a town municipal area is extended to a say erstwhile village, whether that part will still be a village or will become part of the town committee.
It seems if it's included in the town area,
Hmm.
then it will be municipal.
Municipal.
Common parlance.
That's it.
Lordship, revenue villages are something else, lordship, because in Guwahati also, lordship, there are many villages. Suppose Ulubari, then Barsapada, Beltola, these are the villages, lordship.
but included in the town area.
Yes, lordship, these are there. This is for revenue purpose only. They.
So what
mark
would be
these
the
things, lordship.
village that is being contemplated in the advertisement?
So here, lordship, being town, word number 10. So when this is words are marked, lordship, these are under the municipal areas.
So she'll be out
Assam,
of
lordship.
that Nis village. What is the name of the village?
Dhing,
Nice thing.
Nij Dhing.
Nis Dhing.
Yes, lordship.
Respondent number 6 is also from ward number 1.
That ward number 1 is where the Anganwadi center is.
Yes.
Center is located.
Yes.
Okay. Mr. Mahmood, you are for respondent number 6.
My lord, I will say I am for respondent number 6. I am working still now since 2014 till today.
Mr. Padgiri, you want to say something?
No doubt, my lord, as far as select list, I am the second in position.
That you have lost. That you have lost. That you have lost. That is gone down the drain. Today, the select list cannot be acted upon in your favor because you have never challenged either the appointment of the petitioner nor the respondent number 6. Mr. Khan, sorry. Dismissed.
All right.
Move Diriba, move Diriba.
My lord, one thing, my lord, I have filed an affidavit. In affidavit, where annexes 6 and 7 is there, but in file I have not said. So I am providing another.
In the copy you gave to Mr. Khan, whether that was there.
No, copies are already served to all.
No, that 6 and 7 is there.
6 and 7 is not served, but lordship
No,
has-
not given to him also.
Then 6 is the appointment letter, 7 is zoning letter. That is only.
Appointment letter dated?
Appointment letter dated 14, 14, 1/6. That is my appointment letter.
This would be annexure?
And 6 in my affidavit. And last one in the SMS, that is annexure 7, my joining letter.
Or something else has come in.
Yes, yes, that's why my letter I am giving. Annexure 6 several orders, but after 3 months it is extended, and now it is finally decided.
Okay.
Highly obliged.
Not Babu, not so.
Timing 12.
All right, so nothing. No. 12 was in. Ratipa Kun Nasil. Time losing. Yes, Mr. Chaw.
I'm for the petitioner, my lord. I have challenged the removal order of the petitioner, my lord. Others I previously, my lord. Follow record will be required, my lord.
No need. You argue. 12, I think they had made it timely in the morning. Okay, we'll have it after some.
Hello, can it be fixed any other date, my lord?
You satisfy me that you did not have knowledge. And you have said of mental ailment. Your family was taking around you. I don't find concrete materials to that. It is disputed. So we'll not entertain that.
22.
You are for the petitioner.
Yes, Lord.
Why were you not here?
But I am actually.
Mr. Nath has taken us.
Yes,
He has
yes.
helped you with a decision which covers your case.
My sincere apology before this.
No, no, you apologize to Mr. Nath
Definitely.
and thank him also. Because he has thrown light on an area where this court had real
Yes. Lord.
doubt.
Yes. Lord.
Thank you.
However, Your Lordship, I want to place.
What happened to that application that is pending, that has been concluded? Ms. J case number 14 of 22?
No, Your Lordship.
It's pending.
Yes. Lord.
So what we direct is, there is a Supreme Court judgment produced by Mr.
Yes.
Nath, which says that even the death on the death of a spouse,
Yes. Sir.
a proceeding under Order 9, Rule 13 for setting aside will not abet, and it has to be taken to its logical conclusion.
Yes.
If required, by bringing on record any one of the heirs of the deceased husband or the deceased wife, whoever it is, we'll say that that proceeding will be taken to its logical conclusion.
Yes.
Basing thereon, if the divorce degree is recalled
Yes.
or reversed, then you attain the status of your wife. We'll provide from the judgment itself what would be your status.
Yes.
Thereafter, you will have to approach the authorities staking a claim for pension and pension benefit. Till that time, we are not stalling the pension and pension benefits of the respondent, the private respondent here. Yes, Mr. Chauhan, you wanted to make something.
Instead of amendment, I beg to submit without, it is in just one.
Which one?
That setting aside expired petition is there.
There is a Supreme Court judgment which says that it can be continued.
One fact is, here the fact is that the person has remarried.
That will not take the matter out of the purview of the provisions for recall. Here also the remarriage was there, I suppose.
Yes.
Remarriage will not change, because that is her right which has to be adjudicated.
Yes.
That is why I'm saying, once he has remarried,
He has remarried, the consequences, whatever is there, will follow.
Yes. Yes.
If her status as a wife comes back, then she will be number one. Whatever law has conferred on her, on the estate of her husband, she will get it. You may, for that extent, anyway, you have come in 2016 only.
Yes.
She is there for a long time. Any children from your end?
No, Your Lordship.
No. Then
My Lord.
the submission may be recorded and sent to the.
no, I'll not record that submission, because that would be a wrong submission. Immaterial submission, because I'll be recording a finding, conclusions of the Supreme Court in the matter, both on the manner in which an appeal or an Order 9, Rule 13 application is to be considered, and on consideration what happens, both the aspects have been taken care of. It's a judgment which clarifies everything. We'll pass on this.
If this honorable court permits me.
Huh?
If this honorable court permits me, Your Lordship, then one sentence I may place before this honorable court, Your Lordship.
Yes. Why so much formality? Then.
My Lord, in connection with this case, Your Lordship, the husband of the petitioner who is died, however, in that said case, he obtained this expert in decree of divorce by obtaining fraud, Your Lordship. If Your Lordship go through that page number 125.
Gone. Now at least let him be in peace.
Yes, Lordship. I'm sorry for that. Your Lordship.
Okay.
Much obliged. Dispose of it. Yeah.
23.
Mr. Gogoi,
Well,
this is an appointment of 2013.
yes.
Now, can we give? Anyway, Upenda's was considered.
Yes.
Also consider, Upenda's judgment was passed also considering your concession as well as Jagjit Singh.
Yes.
Jagjit Singh, there is no bar
But in
with regard to
division
time. No.
Yes.
Now, should we not give it a liberal construction, saying that 10 years that is there, that would be from 2013, 23 onwards he will be entitled.
Well, in that case, my Lord, there will be bypassing the division base of this honorable court at least.
No, I'll follow Jagjit Singh.
My Lord, here is another, this honorable court judgment, my Lord, appeal.
after 2007 appointee. So that was the line I was thinking about.
So here, my lord, the appellant appointed in the year 2012, my lord. Para number 2.
No, is Upendas considered here?
In the line of Jagajit.
No, you didn't understand what
Now
Mr.
division
Gogoi
line
is
has
saying.
come up.
Gogoi says the matter is now crystallized that in 2017, you must have completed 10 years of service.
Can it be permissible under Article 141 in the line of Jagajit?
141 is Supreme Court, but 141 in the context of Assam has been decided in a particular manner.
Yeah.
And it is very clear, 10 years. So 10 years would go back to 2007.
My lord, in Upendas, my lord. Para 22, my lord.
You see the concessions made by the State Advocate General and thereafter read. The noting of the concession made by the Advocate General, Learned Advocate General, and thereafter read.
Item 2, para 23, my lord.
I pray, my lord, 2024 matter. I will file one affidavit in this case.
Let him have his
My lord,
satisfaction.
yes.
Yes, read.
It is however heartening to learn the state government has agreed not to terminate the master roll workers and similarly place employees working since last more than 10 years till their normal retirement, except on disciplinary ground and on ground of criminal offense. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as well as welfare measure for the betterment and security of the employees in pension. We accordingly direct the state government to implement the measure without further delay. Besides this, we in the light of decision of the Supreme Court, State of Punjab versus Jagjit Singh, also direct the state government to pay minimum of the pay scale to master workers and similarly place employees working since last more than 10 years with effect from 1/8/2017.
Now, the 1/8/2017 is the date for payment. But the Jagjit Singh has been implemented in that decision from the persons who are there for the last 10 years. So we'll have to interpret Jagjit Singh again.
Yes.
And then apply. Now tell me, okay, Mr. Gogoi, you file your affidavit.
Yes, sir.
Now, in the proceedings here, in your pleadings, you have not highlighted para 42 of Jagjit Singh, wherein the parity, the onus is on you to establish.
Subsequently, I have filed additional affidavit, my lord. On 17/7.
Okay, which post are you drawing parity with?
Operative para 4 and 5. Onward.
No, this is just a reiteration of Jagjit Singh. You have quoted Jagjit Singh. But where is your statement that the work you are discharging and the work discharged by an employee in the regular cadre is one and the same? Not only in the light of the amount of work, sensibility, responsibility, everything must be same. 42.1 and 42.5. Para 42.1, para 42.5. I'm leaving the rest.
Moreover, my lord, I am one and only employee, my lord, served in this post, my lord, in the sweeper.
Heard Mr. A. Gohain, Learned Counsel for the petitioner, also heard Mr. B. Gogoi. learned.
Finance, my lord. Respondent two.
Also heard Mr. C.K.S. Purva, learned government advocate, appearing for the respondent number 1, 1, 3, 4, 5, 4 and 5. Also heard Mr. B. Gogoi, learned standing counsel, finance department, appearing for the respondent number 2. Also, given the nature of dispute arising in the present proceedings, Mr. Gogoi submits that he be given 3 weeks time to file an affidavit in the matter covering the contentions raised by the petitioner in the writ petition as well as in the additional affidavit filed on 18/7/2024. Prayer accepted. The respondents may so file
One copy of additional affidavit.
may so file an affidavit in the matter. However, such affidavit must also cover the contentions so made by the petitioner in the said additional affidavit filed in the matter.
A copy of the additional affidavit may be served.
Huh.
Only the
Give it. Should I? Why should I record? You give it.
Entry admission, item 31.
Yes.
My lord, the fact of the matter is that, my lord, the petition, my lord, the respondent, my lord, along with my lord, 5 other, 5 others, my lord, approached the, my lord, learned, my lord, labor court, my lord.
They did not approach. They were taken there.
Raised a, my lord,
Ah.
my lord, dispute, my lord. And my lord, their dispute was, my lord, that, my lord, their promotions were denied, my lord. Now, my lord, the fact is, my lord, that they were, my lord, they were working, my lord, they were working as artisans belonging to Turner and Machinist on this, in the organization. And my lord, that was closed down, my lord.
Belonging to Turner
and Machinist, my lord. My lord, I have explained in para 9 of my petition, my lord. That admittedly due to closure of establishment of wagon repairing shop NFL Pandu, the artisan staff belonging to Turner and Machinist, etc. of the said organization were deployed mainly in Lambing.
So show me the law
My lord.
which permits you that the machinist and the turner would be amalgamated, combined for the next promotion to senior technician. Because you have just made oral statements. You have not brought on record any material.
my lord.
So where are the rules? IREM or the Indian Railway, in the Railway Act, wherever, somewhere it has to be prescribed.
Yes, my
Where?
lord. My lord, before going to the rule, my lord, I like to explain the facts, my lord.
No, I've got it. We have explained the matter on that. But where is the rule holding the field that the promotions would be held in this manner?
Yes, my lord. That is here, my lord. My lord, para 10, my lord. My lord, I have, my lord, mentioned the, my lord, the notification, my lord.
Para
Para 10, my lord.
Para 10.
That the petitioner begs to submit that in the context of Railway Board circular pertaining to restructuring of certain Group C and D cadre, certain standing instructions were earmarked height number so and so dated 9/10/2003 as on 1/11/2003, stating that this order will be applicable on the regular cadre excluding surplus and supernumerary post, my lord. He is, my lord, talking about this, my lord, this circular, my lord. That this circular has not been followed, my
No,
lord.
he is not making a submission on this circular. He is saying that once they were amalgamated in the other workshop,
My lord.
they should have been brought into the regular cadre. You continued to keep them in the supernumerary post. You have not brought them into the vacancies in the normal cadre.
Right.
If you had brought them into the vacancies of cadre of tuner,
My lord.
he would have had a better claim than Rabha for that promotion.
So, my lord, thing is this, my lord, Radha and my lord, this
this.
Are both different?
No, my lord, separate, same, my lord.
Same.
Same, my lord.
That is what I want. Show me that.
No, my lord, now thing is this, my lord, only, my lord, their traders separate, my lord. And
That is what, Mr. Goswami,
Commission,
that
my
is what Mr. Goswami.
my lord.
Okay, let us hold one, this 9-10-2003 is not applicable. But you on your own amalgamated both the cadres. Why? Because of the amalgamation, a machinist got a promotion to the cadre of senior artisan or what, MC or something, master artisan or something.
Yes.
How did you make that amalgamation?
Yes, my lord, that is, my lord, not, my lord, clarified.
Then we will interfere.
Yes, not.
Then we will not
But, my lord,
interfere.
Before going to that, my lord, amalgamation, my lord, what is their, my lord, basic, my lord, my lord, claim, my lord, that they were not promoted, my lord. Their claim was that they were not promoted, my lord. And, my lord, what happened, my lord, during the pendency of that, my lord, proceeding, my lord, Mr. Rabha was promoted, my lord. And, my lord, suddenly, my lord, his, my lord, claim changed, my lord, that Rabha was wrongly promoted.
You come to page 23, para 19, 18 and 19.
Page 23, para
18 and 19.
my lord. My lord.
In the instant case, so and so, number fixation of so and so as well as so and so and not existing percentage so and so equal and are entitled to be promotion so and so whenever two posts are created, but the fact remains show that 3 posts were created, but the workmen were not. From my above discussion, having heard and taking into consideration decisions of so and so, it can be safely held that the management had failed to implement the procedure for restructuring of the post in the event of redeployment of the workmen in so and so. And they were given the status of supernumerary by holding, creating, while the management, ignoring the restructuring formula and other guidelines issued by the railway board from time to time, as discussed above, promoted the man from the machinist grade to the post of master craftsman. Just show me that it was permissible.
My submission is that, when they, demand was raised, they raised before the labor code, their only claim was that, they should be promoted, Once, and Mr. Rabha, was one of them, And during the pendency, Rabha was promoted, Now, his claim says, now he is challenging the promotion of Rabha.
Rabha was promoted during the pendency of the proceeding.
No, man.
Yes, madam.
When was the date of promotion of Rabha?
1/6/2006. And this reference was made thereafter, my lord. That's why.
That is it.
Lordship may kindly come to page 17, of the
70.
judgment, judgment,
93.
Page
And he
17,
got his turner promotion as
page
turner.
7, In course of cross-examination, WW2 stated that during the pendency of the proceeding, other worksmen, namely N.G. Mitra, Khagen Singh, Kaliram Barua, H.G. Rabha, and Sopanda Das have been promoted, and they are not interested to proceed with the case. And the union also not interested to proceed with these 5 workmen who ventilated their grievance before union in black and white. So, during the pendency, they were promoted. If he has any grievance against Rabha, he should file another probably raise dispute.
Now take para 5 of the writ petition. Bottom. A copy of the promotion order of such and such 1/9/2006. At the last page of the writ, annexure. Page 29. They annex the promotion. Now your lordship see the award, my lord, the very beginning, page 12.
What is the date of this order? 1/9.
Yes.
No.
Well,
order,
This is with effect from 1/9.
1/9.
But what is the date of this order?
The only single page is added, my lord, in the.
Mr. Goswami, you have read about names of certain persons. What are those? You were reading somewhere. The persons who were there with him.
My lord,
what are,
First page, my lord, of the order, my lord,
Huh.
at page 12, my lord, Lordship may kindly see. My lord, what I got, my lord, I may be wrong, my lord. Subject to.
NG Mitra.
My lord. My lord,
This reference mallet
my
came
lord,
before
my lord,
39.
first para, my
Okay,
lord.
wait. Yes, Mr.
Para 1, my lord, award. My lord, the schedule whether the action of the management NFLA by denying promotion Sri Subhash Banik technician, grade 1 Turner and 5 other as per annexure is legal and justified. If not, what relief they are entitled. My lord, now para 3, my lord. Be it mentioned here that remaining 5 other workmen, NG Mitra, Sri Khagendra Singh, Sri Kaliram Borua, H.G. Radha ST, Sopan Das, you unreserved appear through their general secretary.
Mr. Just clarify page 29. Date of this order.
My lord, date of this order, my lord.
This is with effect from 1/9/2006. But what is the date? Then we will understand para 3.
Second page is not there.
My lord, page, my lord. My lord.
Page 29.
My lord. I'm sorry.
The order
So sorry.
which is there.
Page 29.
Because you have in your para 5 referred that order as 1/9/2006, which if that be so, then that does not tune with para 3. So it should be a date subsequent there too.
My lord, my lord. A copy of the order dated 23 to March 2013, my lord. I have written, my lord.
Where?
Para 1, my lord, page 2. Award dated, my lord. My lord,
Para?
my lord, para 1, my lord.
No, I'm not on that.
My lord.
The award is of 2013. There is no problem.
My lord.
And your submission is that the promotion of Rabha
My lord.
occasioned during the pendency of the process.
Yes, my lord, what my lord.
No.
Subject to correction. My lord.
I got it.
I may be wrong.
Now, that order is before us at page 29.
My lord.
Just see page 29. And when did you retire?
39/2007.
7, my lord.
Now, the dispute was raised in 2008.
8. Before
After
that-
your retirement.
After retirement.
After.
Before that appeal was made, madam, that's in the page 12. Madam.
Before the Central Labor
Madam,
Commission.
madam. So many application appeal formal was there when the authority concerned. did
Sir,
not take it.
Goswami, have you
29,
got
my
page 29?
29, my lord. Annexure E, my lord.
Ah.
My lord.
Here,
my lord.
the date of this order is not there.
My lord.
Only the effect is there.
Is my lord. With effect from 1/9/2006. Date is, my lord, not here.
Get me this date.
Date is not here, my lord.
Get me this date.
My lord.
Day after.
Tomorrow.
Day after.
Sure. And my lord.
If that order is in tune with para 3 of the award, then you can't claim.
Madam,
The decision just now, judgment that I passed, will cover.
no. Other day I will submit, madam. I am trying to satisfy. Madam, can it be on?
Tomorrow.
Then to.
Tomorrow, get the order. Only tomorrow, 2 o'clock.
Again, I'm saying, I may be wrong, my lord.
Mr. Goswami, there is nothing to be wrong, nothing to be right. You just clarify that fact. If para 3 and your order of promotion matches, that means till the date he was in service, there was no promotion affected. After his superannuation, then the question he will have to answer is whether he'll be liable to be considered after the superannuation. Then we will proceed as required. But get me that date. And if you can get a fresh copy, nothing like it. Tomorrow, Kali. As prayed for by the parties, list this matter for further hearing tomorrow. It will apni yet
32.
You got my point, Mr. Yes, Ms. Soma.
May I please, your lordship? My lord, the petitioner challenges his dismissal order, my lord, at page 34, my lord. My lord, the basic case of the petitioner is that, my lord, as of today, the petitioner is staying with his first wife. Allegedly first wife, my lord, because he doesn't have any second wife, my lord. Because he has not married any other person other than his wife, my lord. As of today, he is staying with his first wife, his daughter, my lord. As of today, my lord. So, my lord, there was an inquiry, my lord. In the inquiry, my lord, allegation was that, my lord, he divorced his first wife.
So in the inquiry, there were 3 witnesses.
Yes, my lord.
Anju, with regard to this allegation,
Yes,
Preeti and Shiv Saran Mishra,
yes, my lord.
father of your first wife. Where are these statements? You have these statements, madam?
Yes.
Show me.
My lord, the statement of Anju is different, my lord, because she is the person who with whom there is a allegation of remarriage, my lord. But my lord, the most vital important thing is that, my lord, the marriage certificate which was produced, my lord, the second marriage certificate, the department did not make any inquiry regarding the genuineness of that marriage certificate. As of today, the petitioner claims that that is not a genuine marriage certificate, my lord. He has not entered into any second marriage, my lord.
Lordship may kindly come to page 29, the
So that is the only issue which we have to decide now.
Yes, my lord. So, my lord, the issue is that, my lord, as of today, because, my lord, the petitioner in his service book, as of today, his first wife, the name of his first wife is there, my lord. Only in the service book of that Anju, my lord, Anju Meena, my lord, the name of the petitioner has been recorded as husband. But, my lord, from the part of the petitioner, my lord, nothing has been done. He has not submitted any divorce decree, my lord, decree of divorce between his and first wife. He has not submitted before the authority. He has not submitted the second marriage certificate, my lord. So the authority inquired regarding the genuineness of the divorce decree, my lord. But they did not.
I'll consider that 2 issues.
Yes, my
Vital
lord.
issues.
But
Just have your
they
seat.
did not.
Just have your seat, Mr.
Yes,
Bora.
madam.
Yes, Ms.
Lordship first, Lordship may kindly come to page 29 of my affidavit. That is not running page, but page 29 of my affidavit. Lordship got it?
What is that annexure?
Annexure B,
Statement of
yes, the petitioner. So, from fourth paragraph.
just a moment. Just a moment. The inquiry report or the opinion of the court is at page 13.
Yes, my lord.
Opinion, Lordship.
Is there any other inquiry report? This is the one?
Yes.
Okay. So page 15, last paragraph is the finding with regard to the second marriage.
This is irrelevant, my lord.
That's it. That's your submission. Now, show me your statement
My lord, that
against the inquiry report. Inquiry report was given to you.
Yes, my lord.
And what is the statement with regard to
My
these
lord,
2 findings?
The petitioner is not relying on his statement because, my lord.
No, I'm not on a statement. I am on the finding that was recorded by the inquiry officer.
Yes, my lord.
What is your reply to that? Ms. Sharma, take your seat.
My lord, paragraph 15, last paragraph, that from the perusal of the service book of Constable Upendra Kumar Pandey, it has come to know that the Constable Upendra Kumar Pandey has solemnized the marriage with Srimati Preeti Pandey under the Hindu Marriage Act 1955, and Constable has not mentioned the factum of his divorce from his first wife. So he's not disclosed, my lord. And the second marriage has been solemnized by the Constable with SI Anjumina, and the said details has not been recorded in the service book.
I'll hold it. This is perverse.
Yes, my lord.
But where is your stand against that? That finding, where is your stand?
My lord, in
Now that
my-
you are making a submission that, see, the marriage with that lady
Yes, my lord.
is her own creation, not mine.
Yes, my lord.
Where is that
My
statement?
lord, in my petition all along in so many paragraphs I have
Not
pleaded.
in the writ petition, before the authorities, appeal, or in a representation against the inquiry report. Where is that statement?
My lord, in my so-called reply, my lord.
Okay.
Annexure 6, page 23, my lord.
Annexure 6, page
23, my lord.
23. Okay.
The relevant portion, page 27, my lord.
Hmm.
Page 27, my lord.
Come to page 25.
5, Lordship. B,
B.
clause B.
The allegation has been charged against the that he was entered into so and so. This is your document.
Yes, my lord.
As it is said, the petition entered into second after obtaining decree of divorce from his first wife, and the degree of divorce has been taken mutually, and as such, no complaint has been made either from the first wife or second wife, as both are happy in their life. And the petition also begs to state that two marriages that has actually not happened, then also aforesaid facts are not related to the duty of the petitioner.
Yes, my lord.
You two marriages, not because at the same time you did not marry two
Yes.
times. You divorced and
No.
then married. So where is the consistency?
I did not divorce, my lord. And
See, as it is said, entered into after obtaining from the degree of has been taken mutually, and such no complaint has been made.
as it is said there, my lord. As it is said there, the petitioner entered, as it is said, my lord, it is the complaint against the petitioner, my lord. As it is said, my lord, the contention of this paragraph is that assuming that the allegation is true, my lord, that otherwise also, my lord, that cannot come into his way because of this. It is not admitted, my lord, paragraph B. Paragraph is not admitted. As it is said, my lord, as it is alleged, my lord. Even if the allegation is true, in that case also, my lord, that should not come in between his service career. That is the contention in the paragraph B, my lord. He has not admitted it, my lord. And in paragraph clause E, my lord, page 27, he has specifically stated, my lord, the aforesaid court of inquiry, which is baseless and illegal, has taken signatures of the petitioner and his family members on many blank sheets of papers. The petitioner in this regard begs to state that if those papers have been used to conspire against the petitioner, then it is not coincidence. My lord, and paragraph B of page 25.
You have the appeal submitted by the petitioner or the inquiry report against the presentation.
Lordship may kindly come to page 21 of the writ petition. This is the so-called notice. It will clear, Lordship may kindly, he had even submitted a false decree of divorce, which
No,
was
no.
not of him.
In his show cause reply, there is a gray area. He is denying that.
Yes, my lord.
So thereafter, the inquiry, court of inquiry, everything proceeded. The statements also, for the time being, we will give him a long rope, wherein he says those signatures were taken. Very far-fetched,
I have denied those, yes.
but that also you forget it. Now the next question is, there was a court of inquiry, there was a report that was given to him. He has submitted a reply. Where is that? It's not on record.
It is not with me also, my lord. My lord, from the point of the petitioner, the case is simple, my lord. As of today, my lord, the first wife, she is staying with the petitioner, and I can produce her before your lordship also, my lord. In Guwahati, she is staying with the petitioner, my lord. As of today, my lord. And there was no any divorce decree passed against them, my lord. The petitioner has not entered into the second marriage, and that second marriage certificate, if that is verified by the department, my lord, then it will come.
How old are you now?
Yes, my lord.
How old are you now?
My lord, as of today, he is my lord.
At that time, 33, 2019. So now 38, 39.
Yes, my lord. Because my lord, the main basis is the LAP, basis is the marriage, second marriage registration certificate.
So what about these statements that were recorded? Have you denied these statements?
My lord, in my petition, I have denied because I am saying that, my lord, those statements have been, because they took my signature on blank page, my lord. And otherwise, my lord, apart from the statements, the record is more vital, my lord. What the record says, my lord. As you may, keeping aside the statements, my lord, the record, my lord, the second marriage registration certificate, if that is verified, and if that is found to be genuine, then the
Madam, do you
petitioner
have
doesn't
the appeals representation submitted by him on record with you?
Record is not with me.
The appeal copies and all?
Lordship,
Appeal copy.
appeal copy, yes, I have annexed.
You have annexed. Where is it?
Order.
You have, the order is on record,
Order
but
is on record.
where is the appeal memo?
Appeal memo is not on record.
We just want to clarify on this statement.
Lordship, that is lordship, if he had not even divorced or he had not entered in a second marriage, what is necessity for him to produce a false divorce decree?
See,
That is also
that
there.
is again, that is what I'm saying. That is again there in the statements recorded by him in the inquiry. Therein he has made those statements.
Yes.
But his contention is that those papers on which the statement was so recorded, he had signed on blank papers.
Lordship, I have.
You denied it.
Yes, Lordship.
Forget it. You denied it.
Yes.
But I want to know, he filed an appeal.
Lordship.
Whether this point, because these issues
Yes.
are there in the order of the disciplinary authority.
Whether
He has
in
taken
that
those
ground or
pleas
not.
in the appeal.
Then I have to call for the
Get
records.
the records.
And one more thing, my lord, there is
This is in Guwahati only.
This be 33rd
Sonapur.
Battalion. Yes.
Sonapur. We'll have it on Thursday. You get the records.
Thursday with
Friday.
next week, Lordship. May not be.
Friday. We have heard it. We have read it also. Friday. You make a phone call, they'll come running.
Let me try, Lordship.
Or ask Mr. Chaudhary to do the needful. He can walk up to Sonapur, no problem.
Lordship.
And my lord, I would like to rely on one judgment passed by the division bench of this honorable court. The issue is squarely covered by this judgment, my lord.
It is only on proportionality, Lordship.
Yes, my lord. The punishment, my lord, because this judgment recommends for my lord lesser punishment. Considering the
I'll proportionality, I'll go in if I'm satisfied.
yes, my lord.
That
it is the second
that
aspect,
you
my
had
lord.
not submitted any forged decree of divorce.
Yes, my lord.
Because that contention of yours that these were all done on papers, blank papers signed by you.
Yes, my lord.
We find it a bit difficult to accept.
Yes, my lord.
But
If
we
it-
want to confirm that with the appeal, whether you had
Yes, my
taken
lord.
a plea.
Not only appeal, my lord, whether the divorce decree has been submitted by the petitioner, my lord.
I don't know, because in the order, there is a reference to that, your submission.
That is
If
in
you
the-
come to page 34,
Oh,
order,
yes, my lord, it is there in the order.
I want to see how you have dealt with this.
Yes, my lord. Yes, I understand, my lord.
Friday. Heard Mr. D.P. Bora, Learned Counsel for the petition, and also Mr. Miss B. Sharma, Learned CGC, appearing for the respondent. Upon hearing the parties at length, this court requires Ms. B. Sharma to produce the records pertaining to the proceedings initiated against the petitioner, including copies of the representations that he may have submitted against the opinions of the court of inquiry, as well as the appeal so preferred by him, appeal memo, copy of the appeal memo so preferred by him against the order dated 29/6/2018. Ms. Sharma, if these statements are there, then the matter would get a different color altogether. We'll see.
Oblige, my lord.
Item 24,
Mr. Chaudhary, you are waiting for what?
Well, it was customer.
We'll just finish up Mr.
Yes, yes.
Soikia's case.
Yes.
Heard Mr. M. Soikia and counsel for the petition. Peruse the office note dated 26/7/2024, which reflects that notice for service of steps for the notice was issued upon the respond number 1 to 5 only on 16/7/2024. Registry to list this matter again after 4 weeks with a report pertaining to the status of service of notice upon the said respondents.
Lordship, I am appearing for respondent number 1,
Miss
N. Bora.
N. Bora has entered appearance for respondent number 1. Who is that? Eka. Mr. Eka. Okay. The said respondent is to file his affidavit in the matter by the next date of listing. Now, 12 tomorrow.
Time being 12.
Yes, Mr. Chaudhary. Mr. Counsel for the Mr. Chauhan, there are gaps. The materials, certificates that you have brought on record does not reflect that you were incapacitated from at least informing the authorities or your family members inform. You are sick. You are a employee. Everybody knows in your family that you are serving in certain organization. Now that these problems, very genuine problems, you are suffering, we hold that you don't know. But what happened to your family? Why had they not? Because all these communications sent by the SSB authorities were going to your house. And where will they send if not to your house? And there is one more thing. I'll just clarify my mind to you. Where is that certificate from that doctor, intermediate doctor, not the
51.
51? If you see, the certificate is on record, but the treatment particulars you had received are not there. And in 2010, this doctor had asked you to go to somewhere in that PHE where you were first treated, directed you to go to Tezpur.
My lord.
But you did not go there till 2013. Now, once you were there in Tezpur, why have you come back to this person?
Whatever he is suffering from mental illness, my lord.
I got it. I got it.
he
You
was-
went to Tezpur. You were being treated there. What made you to come back in 2016 to this man? You could have got the certificate from.
No, my lord. Since 2010, my lord, I was under.
Come to
treatment.
the last but one paragraph.
Page number 51, my lord. I was treated there since 2010, my lord.
I got it. Come to the last 3 paragraphs. Recently, the petitioner attends me with medical records of so and so, and the records reveal good treatment compliance. Patient is found to have improved significantly with subsidence of all oddities. Now I am in the opinion that the petitioner is fit to resume his duties. However, he should be given light duty, avoiding sleep, so and so. Now, why was this certificate not taken from the authorities of the hospital at Tezpur?
My lord, at that time I was suffering from mental illness, my lord. Even I was not staying at my residence, my lord.
No, again, that also, second paragraph, there is a doubt created. You come back, the family members bring you to him.
My lord, moreover, my lord, this.
And
all the
your
input order-
statement is that you are staying with your child.
My lord,
You are staying with your child. Right?
no, I am roaming here and there, my lord. Even I cannot say where I am living, my lord.
No, my only question is, why was this not communicated to the authorities?
My, who will communicate? My wife is already at that time was dispute because of that. My lord, I was frustrated and sick mental problem.
You have
my
your
lord.
family, other family members. Who are the members bringing you
Wife-
for
wife,
treatment?
Child, my lord.
No. There are attendants bringing you for treatment regularly to this doctor at page 51.
And apart from that, my lord, all the impugn order was passed without serving any notice to
No,
me.
they had sent each and every copy right from the date of your apprehension rule to
Everyone
deserter
that was-
to your house.
Yes, my lord, but police could not apprehended me. Because,
That is again doubtful. What happened, what not happened. But the communications were going to your house, you were sending it back.
my lord, even postal endorsement said that he is not available at the residence, my lord.
But how can you say that they had not communicated those orders? They have communicated.
My lord, in this respect, Supreme Court is very much clear, my lord. If communication was not made properly, he would have been.
What is that
published in
proper
newspaper.
No, what would be that proper communication according to you?
My lord.
They will find out where you
My
are.
lord, as per apex court, my lord, first to send notice. If not served, then attempt second or third time, then time of paper publication, my lord.
You are a madman. How will you look into the paper?
My lord, that is
Because that would be if they had not sent the notice to your permanent house. They had sent the notices to your permanent house. Once that notice reached there, General Clauses Act, it should be deemed to have been accepted.
my lord, in this case, Supreme Court is very much clear, my lord.
We'll go to the Supreme Court, don't worry.
My lord, notice have been served, first attempt, second attempt, then after publication, paper publication. Then after his.
And if somebody, we draw a conclusion that you were knowingly avoiding, then
For that, my lord, that my regular department of proceeding would have been brought, my lord. That was not done.
no, okay. When you joined the service, purportedly you went for joining.
My lord, 25 for 2000, my lord.
No. After that, you went for joining, but there was not allowed.
My lord.
After the 2015.
My lord. That is.
Okay. Now come to page 44.
My lord, page 20, my lord.
Hmm.
5/12/2015.
Hmm.
Request for rejoining.
5/12.
2015.
Page?
Page 20, my lord.
Okay, read this.
Rejoining.
So and so, so and so. And got medical treatment in Lokapriya Gopinath Bodle Institution of Medical Health,
My lord.
Assam, for which I could not resume my duties after expiry of the third and leave. I also could not communicate. Now I am living with your son, so and so. My son is so and so. So and so. I got full recovery. Now, where is the treatment that you received at page 51?
My lord.
51.
51, my lord.
That doctor,
My lord.
Riazul Hamid.
My lord.
Where is the reference here? And when you have gone there with this, why have you not annexed the medical certificates?
My lord, that should be examined by the authority, my lord, by proper departmental proceeding, my lord. That was not done, my lord.
When was the leave? When did you take leave?
My lord.
When did you proceed on leave?
Leave, my lord, 5/10/2009 to 3/12/2009.
5/10/2009.
So 3/12/2009.
3/12/2009.
4/12 onwards, you are absconding. Now, there is a conclusion reached in the order at page 59.
My lord. This is appellant order, my lord.
Come to the last paragraph. So you had no problem as on 5/10/2009 till 5/10/2009, the mental ailments were not there, right? You had not gone to your house for the last around 2 years from 2010. That means you have not gone to the house from 2008.
My first treatment started on 30/11/2009, my lord. Page 50.
Page 50.
Page 50.
Dole. Okay, this we accept. Here the advice is to go to the hospital, Lokopriya Gopinath Bodle Hospital at Tezpur. But you reached Gopinath Bodle Hospital in 2013. From 9 to 13, where were you?
In between, my lord, I have taken treatment, my lord. Page 51, my lord.
51 is not supported by the other records.
My lord.
When you submitted the joining report in 2016, you never mentioned that you had also taken treatment of one Riazul Hamid.
My certificate is clear, my lord. He was under treatment 1 to 2010, my lord, page 51. And there is a OPD number is also there, my lord. And top of the, yes, my lord, 112890.
Yes, Mr. Chaudhary. Rightly, wrongly, there is some inconsistencies in the matter. But the claim of the petitioner is that he is mentally retarded or mentally ill. Now, was it not a duty of yours to have that verified, at least?
Now, the question is, when will we verify? Here is a case, Lordship, where he was not there for years together. 2009, 2015,
15.
16. In the meantime, whatever steps that we were required to take,
You have taken.
those have been done. Now, let us, for a moment, if your Lordship was referring to page 51, just for a moment, I will. The doctor says in paragraph 2, he was brought to him on 1/2/2010. What treatment was done? This is only a certificate issued in the year 2016. We can well understand that he was under treatment. What treatment? There is no prescription history, and Lordship will see how did he go to the mental hospital. Lordship will just see page 52. Page 52.
Outpatient.
Referred by. He himself went there. Said Lordship.
No, Mr. Chauhan, my query is, were you incapacitated to such an extent that even a communication could not be made? You are moving around. You went to Lokopriya Gopinath Bodle. You went to page 51, doctor. So, satisfy this court that you were not in a condition to even inform. Mobile is not there at that point of time, but at least that information you ought to have given. Only satisfy me on that point. That by the documents that you bring on record, I was totally incapacitated. Mental ailments has a lot of facets to it. You are not a schizophrenic. You were in depression. If I go by your documents, you were in depression. And I don't know why alcohol abuse has not been used. Ethanol abuse has been used. So either you were 24/7 under ethanol abuse, or in the mornings at least you were sane. What prevented you from making an application C or asking somebody, because it is not reflected from the records that you were incapacitated? I'm only on the question of information.
Even though, my lord, the authorities should have made a regular inquiry. into
Why?
that aspect, my
Why?
lord.
If you are not there, they came to know that you are mentally ill in 2015. From 2010 to 2015, they don't know. You are missing. You are missing. So when you went there for the first time in 2015, you did not carry the medical certificates. Subsequently, things are coming on record.
No, my lord, that was submitted, my lord.
What is your name? Banjit Das.
Manjit Das, my lord.
Hmm. So, where is, even in page 51, where is that finding that you were incapacitated?
The first paragraph, my lord. He is suffering from psychological illness and long duration, and illness is severely
So,
disabling.
that long duration, severely disabling, affects dimensions with social relatedness, occupational functioning, mental tranquility, and he was under my care from 1/2/2010. Now, what was the care? What were the medicines? Were you admitted in that hospital? And there is attendance with you all along. And what are the psychotic symptoms you had? These are required for this court to understand that you were incapacitated from. I'm only on that point. Yes, Mr. Chaudhary, that's the only thing. I'll not be harsh here. I'm no rush. You develop your case on that line. Just show me that you were incapacitated from the documents to even make a communication. That is enough. Then we'll ask Mr. Chaudhary to do the needful with regard to examination of your medical certificates.
At that point, we are also, because my commandant is not competent authority so far as section 11, my lord.
Section 11, the commandant is the authority. You are just a enroll officer, SSB.
No, my lord.
Yes, is there any? Mr. John, you are on unauthorized absence. First establish your that point, then we will go into the other question. And the police went to your house.
My lord.
Nobody informed the police that you are suffering from psychological problem.
Police also examined the villagers, my lord. Also examined the villagers.
There, nobody said there is no material. Is there any material to show that you were?
All said that he is not available at residence. my lord.
That is that if you might be working somewhere else. And you were suffering from so much of a mental problem. You were not knowing what you were doing from 2010 to 2015. But in your appeal, you have depicted the facts in a very chronological manner. How? page 45. Every date of your treatment is very chronologically brought on record. How? If your mental faculty was not working at that point of time, you don't know what you did. That is your projection in the writ petition. That you did not know. But how this meticulous placement of the dates are there? That raises the doubt. So you know the mind of the court now. Please prepare on that lines to dispel this. If you bring up something material, we will not even hear Mr. Chaudhary. But I want it to be established that you were incapacitated to such an extent that you could not even make a... And for that, this, just see how it is beautifully placed. January 2010, 1 to 2010, June, July 2013. Because according to you, other than you, nobody was with you. Who gave you these dates? Because you should not know that you went on 10 to some hospital, PHC. Thereafter, you were taken in 13 to page 51 doctor. And thereafter to Lokapriya Gopinath Bodle. Because you were going here all alone. You had nobody. How this meticulous date chronologically has now been placed in the appeal. Friday. As prayed for. I heard the parties at length. As prayed for. List this matter again on Friday for further consideration.
Next week, my lord.
Friday. I'll forget. Only, Mr. Chauhan, this much, any decision you want to rely on, that only a plea of insanity is enough. No further materials are required to be produced. I'm with you. Anything more, Mr. Chaudhary?
That's page 51 makes an interesting read.
No, I'm not on in on page 51.
Oh.
His contention in the writ petition, you will find that he was not knowing what he was doing. He used to remain away. But you see his appeal.
I have seen it's very clear.
Chronological.
I was
There
just-
has to be some, what do you call that? What is that appropriate word? Some discrepancies in this appeal. That would have supported your case.
File July 2016, my lord.
On a lighter note, if your lordship will see page 51,
Hmm.
lordship will see the heading.
Hmm.
He's an expert in resistant schizophrenia and alcohol de-addiction. By this time, he might have been de-addicted and everything has flashed back on him.
Just show me. My sympathies are with you. Just show me. Just on that point. That'll do. Yeah.
Other points also.
33, 34.
Huh?
Others point also be considered with this.
First, clear. This court has somehow got it. Get this thing out from my head. Then I'll consider anything you want me. Yes, Mr. Bhuya. Now that you are here, we can openly impose cost.
My lord,
See, this is not done for.
My lord,
26/6/2024 gave you 1 month. 29/7/2000.
My lordship is merciful, and I think that my lord, pardon me, my lord, it is purely on my personal mistakes, my lord.
No, submission made is
My lord.
that the clients were contacted, they did not respond.
No, my lord, no, that is my friend's submission. My lord.
33, okay.
But in my lord, in item 34, initially we have taken steps, my lord, to
I
all
got
the
it.
respondents. But my lord, what has happened, some addresses, I have gone through the entire Lozima court's order, my lord. It is very elaborate and categorical, my lord. And once I go through the Lozima court's order, my lord, ultimately we have required to take in steps up to certain respondents, which I have recorded today, my lord. And secondly, my lord, what has happened, my lord, although, my lord, I am fully, my lord, take apology from my, no,
Once Mr.
my lord,
Bhuya says it is on his head.
my lord.
So when will you take steps?
My
Today?
lord, by the,
Tomorrow.
by next Monday. my
No,
lord.
no,
My
tomorrow.
lord, I'll take.
You are not taking. So we are dismissing your petition. Item, your Mr. Bhuya, your case is
34 my lord.
34.
Farooq Ahmed.
আপনারও ফারুক, no? ফারুক।
Farooq Ahmed.
Farooq Hussain Mazumdar, my lord.
Farooq Ahmed Mojumdar.
My lord.
Many briefs, so sometimes the names get confused for Mr. Bhuya. So there is no problem. Mr. Bhuya, learned counsel appearing for the respondent, for the petitioners, submit that the steps in the matter submits that in pursuance to the orders, directions passed by this court-wide order dated 26/6/2024, the steps upon the respondents, that is
13, my lord. It is reflected in the Lodima Court's order. dated-
respondents number 3, 4, 5, 6, and 7 could not be inadvertently, could not be taken due to
No, my lord.
the same had missed his notice and also the ensuing vacations. Also, however, he submits that the steps in this matter would be so taken by Thursday.
3233.
Thursday.
My lord, it is in respect of my learned friend's petition, my lord.
Okay, sorry.
My lord, in my petition, my lord, may be pleased to find, it is the order dated 7/6/2024 passed by the Honorable Lodima Court, my lord.
Okay.
And wherein lots of respondent has been recorded, my lord.
14/5. Oh,
7/6/2024, my lord, may kindly.
7/6, okay.
My-
So and so inadvertently failed to take steps upon the respondents number
13, 14.
13, 14, 18. Page 15. right?
No.
However, he assures this court that the steps in this connection would be taken by Friday without fail.
Right.
Also, in view of the said submission of Mr. A.R. Bhuya, the present writ petition stands adjourned. The petitioner is directed to take steps in the matter without fail by latest by Friday. That is date to review. Also, it is observed that in the event the steps so directed are not taken by Friday, the writ petition would be listed again on Monday, Wednesday, next date on which date this court would consider as to whether the writ petition would be required to be dismissed for the said default on the part of the petitioner herein.
Right.
Also, if the steps are so taken, the registry to issue notices upon the respondents involved by way of registered post with AD post and the matter be thereafter listed after 4 weeks. Also, তার পিছত এটো আপনার 4156 বেলেগ order হবে 4322/2016. Ms. Deb submits that the steps upon the respondents number 3, 4, 5, 6, and 7 were not taken inasmuch as the petitioners, in spite of being informed of the said position, had not responded. And accordingly, she submits that no steps would be permissible on her part to be so taken without the petitioners cooperating in the matter, and accordingly prays that this court may be pleased to. And accordingly submits that the present writ petition may be closed by this court. So, in view of the said submissions of Ms. S. Deb and a default having been committed in taking steps in the matter, and there being no assurance that the steps would be so taken in a short time, this court is left with no other alternative but to dismiss the present writ petition for the said default.
Obliged, highly obliged.
Hearing item 25.
Lordship, in this matter, Lordship.
Perhaps your lordship would not like to
Take up the matter, Lordship.
I was there.
You're not there, but Lordship, I had a casual talk with.
Huh?
I had a casual talk with your Lordship.
Oh.
In this matter, Lordship.
List before any other bench without me. So, you can have anybody else has a casual talk with me. The other matters also I can go then. There.
May I please?
Hmm.
Here the petitioner was dismissed from Sambris while he was serving as constable, madam. And he prepared an appealment that the appeal also was dismissed, madam.
Madam, have you gone through the inquiry report?
Yes, lordship, little.
Have you gone through?
Yes, lord.
In the appeal, madam, the appeal authority admitted that madam, there is a violation of 311(2) of the Constitution of India, madam.
Who admitted?
The appeal authority.
Absolutely. Now, if you come to the inquiry report, madam,
Yes,
Lordship.
it starts at page 87. Right? So, right? Starts at page 87.
yes, madam.
Then,
The page 93, but this is the finding of the inquiry.
wait. I mean, with you only
Yes.
in this matter. You take your seat. Relax. In the 87, madam, you will find these are all discussions. Okay? Charge is there. Then the discussions start. Then the witnesses are cited. Next page. Okay?
Lordship.
Documents are reflected. Then he starts to record the statements of the prosecuting witnesses.
Lordship.
Right? This goes on till page 92, wherein the defense statements are recorded. Right?
Lordship.
Now, 93. Now you will have to understand one thing. The charge against the petitioner herein is page 25. At that time, you along with your partner, younger sister of the complainant and one unknown entered into the same. You opened fire at her parent and fled away towards the backside of the house. As a result, so and so committed inquiry. Right? This is the charge. Now you come to page 93.
92.
93, ma'am. Inconsistencies in this statement. So, first one is, Sahara Khatun stated that Biman Fukan is son-in-law, which is inconsistent with the statement of the delinquent.
Delinquent.
How does it connect to the charge? Second one, so-and-so stated that on so-and-so came to Paltam Bazar at 8:10 p.m. in his Maruti car while he was doing sentry duty, which is inconsistent with the statement of SI
Yes.
Gyasuddin Khan. Gyasuddin said came around 7 o'clock. Now, the incident occasioned at Bahishista at 8:10. At least he is in, what do you call that? Paltam Bazar police station at that point of time.
Lordship.
So how can his presence be recorded there? No material. Now you come to the findings. Having found subsection against so-and-so, case was submitted in so-and-so. As per statement of so-and-so, vehicle was found in place of occurring bearing registration is found to be in the name of so-and-so. From the above statement of PWD's evidence on record, it is well established. Charges of misconduct levied against the delinquent. So from where does he get this last paragraph? And this vehicle recovery that your appellate authority says is a wrong thing.
Lordship, I understood. I also, yesterday, I wanted to inquire from them, Lordship.
You do that.
Yes, Lordship, but yes.
What happened to the criminal case?
It's still pending, Lordship. That I.
The IO statement has to be recorded, madam. And the bio witness are also missing there, madam.
They have gone with 40 lakhs.
Yes.
Madam,
Yes, Lordship.
with this conclusion, the charge cannot be held to be established, even by applying preponderance of probability.
Yes, Lordship.
Nothing. What we can do is, we can interfere with this whole thing, direct that he will be under suspension,
Lordship.
we can direct you to proceed from the state of
Ten.
the inquiry.
But after 2010, my lord, kindly see, my lord.
Now, do you want things against you also?
No, my lord.
Then keep quiet.
For a moment, my lord, because my he's suffering some mental agony, my lord, during this moment.
Because,
He-
see, for this default, we can't ask you to be
Page
exonerated.
49, my the vehicle was in, my lord, Koltam Bazaar, my lord. This is a Sijal list, my lord.
See, if we go by the statement of Gyasuddin,
No, my lord, Gyasuddin said during investigation, the vehicle was seized, my lord. And in page 49. it is
just
Sijal
a
list, my
moment,
lord.
just a moment, just a moment. Huh?
Yes, my lord. In page 49, it is Sijal
But
list, my lord.
so and so, so and so, so and so, so and so, so and so. Mm. There is some statement somewhere, because that finding is wrong. But
Yes,
there
sir.
is a statement somewhere of your being
If I'm not this,
in the police station, Paltam Bazar police station at 7. 2 times a day.
Yes, sir. My lord, kindly see.
Madam, please have a talk with your authorities
Yes, Lordship.
on this and then come back to me.
Yesterday they could
Huh.
not answer. And I want to go to.
PS at 7 p.m.
Yes.
Hmm? And in the appeal, you said 8 p.m.
Yes, yes. There is some-
So
some
there is a
contradiction.
gap between one,
Yes,
one,
yes.
1 hour. And
1 hour.
for 1 hour, go at that point, going to Boxista and coming back may not be that difficult.
But in the proceeding, my lord, he is saying in 8, my lord, he was in Koltam Bazaar.
8:10.
Yes, sir.
He was in Paltam Bazar and he has recorded. He might have come back because there are statements of his wherein he say he was there at 7 p.m.
In the appeal, my lord, he is inside my ward, my lord, this 7 p.m. my lord. But in the proceeding, my lord,
And the incident is of around 8 o'clock. 8:10 shooting.
8:15, my lord. But
That is again not an exact time. It's an presumed time by Mina.
if you go by the my lord, Gyasuddin, my lord, statement, my lord, kindly see, my lord.
I'll not go into, but
Yes,
I'm not satisfied with the manner in which the inquiry was,
Yes, madam.
conclusions were reached. Yes, madam. Thursday.
Admitted that the presenting officer
Lordship.
was not.
Can it be on next Tuesday, Lordship?
Tuesday
Okay,
for further hearing.
Because I want to. go
Heard the
for
learned council for the parties.
furniture
Matter heard at
statements
length.
Also, Lordship.
List again on Tuesday for further hearing.
Can it be on Thursday, madam? I'll be not available.
Thursday, no problem. Thursday. Madam, you get your thing. Otherwise, with this conclusion, we will have to interfere.
Lordship, yesterday I have seen Lordship.
We'll have to interfere.
29.
Yes, Mr. Prakash.
My lord, this case, the second round of litigation. The petitioner has been deprived of, my lord, getting his MSCTS benefit, my lord. So it should be.
He has been challenging the order dated
Which is
6/7/2023.
not in consistence with the, my lord, the ROP. ROP rule itself is, my lord, provides that certain conditions to be followed.
You are claiming MSCP.
Yes.
Okay. What is the claim, MSCP?
My lord, MSB,
How many MSCPs are you claiming? 1 or 2?
my lord, in respect of SCS cadre officer, my lord, they have issued the office memorandum pursuant to the office notification of the ROP 17/3/2017. And office memorandum first was, my lord, at page number 42. It is dated 14/8/2018.
Now, from which date are you claiming MSCP?
My lord, MSP from the he has been serving in my lord since 1995. He has got only one promotion, my lord. Therefore,
When?
One promotion, my lord. Subsequently, my lord, in ADC notification. He has got senior grade, my lord, SCS officer now.
इसी कमाल हो थोड़ा चाहिए बोल इसी डॉलर कमाई लियो है गाली बड़ी बनाने So the speaking order is at page 54.
Lordship.
But he has been given on 2015 ballot. And your lordship will find that in the earlier round of litigation, the order is ballot from of this noble court at page 46, where it is ballot clearly.
So page 55, last paragraph, that is the reason.
Yes.
Huh? Cannot be considered for granting of provincial financial benefits due to pending prosecution sanction against the officer. Charge sheet filed.
Yes.
When?
That two ballot.
Charge sheet filed on?
See, in our affidavit, in regard to charge, it has not been mentioned, Lordship. Otherwise.
2017.
Is the number?
2017.
2017. CBI case number. When was the charge sheet?
On ballot, the exact date is say 15/9/2016.
So that case is still pending.
Yes, that is pending.
Now tell me, whether your case can be considered for promotion.
Not for promotion.
Mr. Professor, asking with some purpose, can your case be considered in view of that pendency of the charge sheet for promotion? It cannot be. Now you come to the rules of that MSCP thing. Where is that?
MSCP rules, my lord, specifically says, my
Where,
lord,
where?
I'm taking it to the judgment, my lord, page 49. The
It's
judgment-
quoted there.
Yes, yes.
Granted provisionally.
Yeah. It can be
And what
granted
was the
provisionally.
amendment made?
My lord,
Amendment made to this? Some clause was inserted subsequently.
so that is, my lord, in the office, impugned office memorandum issued by the authority, my lord.
Where is that?
That is, my lord, impugned office memorandum is at page number 68.
68.
Earlier office memorandum, my lord, 14/8/2018 is modified, and new office memorandum has come on 8/2/2023, page 68.
Now, the orders of this court is based on the earlier.
Earlier,
Earlier.
it's a sentence, that impugned sentence is same in both the office memorandum. my lord.
Here also, see, point number 2, the financial application is subject to condition, there is no.
तुम जाओ जाओ एक गाय बेर से जाओ
The financial application is also subject to condition that there is no DP or criminal proceeding against the officer is pending.
However, if there is a DP or criminal proceeding against the employee, the benefit will be granted provisionally
Yes.
from the same date as in normal case and subject to the following condition. Okay, what do you have to say on this? Provisionally also you are not paying.
Not paying.
And what would this provisionally mean? You will get the benefit in full, but provisionally.
Provision is conditional, my lord. If I become unsuccessful in the criminal procedure, I will refund it in that event also. That is provisional condition. And there are two cases. One case I already have got acquittal. This honorable court recorded in judgment. And moreover, my lord.
Is it of idea?
Notification under ROP cannot be modified like that. No?
Okay. We'll consider.
Okay.
Friday.
Friday.
So this is your case. At least provisionally you must have.
Yes, that is.
Your notification provisionally.
No.
That has been interpreted by this court on the last occasion.
Yes.
And the provision remains the same. I'll just go through it once. Yesterday I could not apply my full mind.
Okay, no problem.
As prayed for by the Learned Council for the parties, list this matter again on Friday for further consideration. Yes, Mr. Mukherjee, what is it?
This is a case where subsequently, after filing of this petition, transfer has been given, Your Lordship. I paid for transfer on the. ground
What
of-
is more left here? That you were given some 41, you wanted some 51.
Have been given somewhere where I wanted, Your Lordship.
Then what
This
is left?
The only thing is that, Your Lordship, the case is that I have paid for this transfer on couple posting based on the DOPT guidelines. They are saying the DOPT guidelines ought to have been followed, their own.
Now, what is the grievance left?
In the affidavit, they are taking a stand that they will not follow the DOPT guidelines.
For them, in a given case, if it comes to that, come back. But you have got your relief.
I've got one.
Then what is left here?
Nothing left. Sir.
Then, if you want, if we proceed with the matter and hold that something, it might even go against you. We might even have to bring you back. So once you have got your relief, why are you unnecessarily? I remember, because last time it was just before the holidays, that's why I did not dispose it.
Yes.
Why giving such people such grievances, huh? You should
As,
die. Where is the order posting you?
It is not.
instruction is there in the
Yeah, okay.
51 battalion Sitamari.
Sitamari, yes.
That was his first posting, Lordship.
And you have given him there only.
Yes, Lordship.
Heard Mr. B.J. Mukherjee, Learned Council for the petition, also heard Ms. R. Devi, Learned Council, as CGC appearing for the respondents. The petitioner in the present proceedings had raised a grievance with regard to the non-consideration of his case for transfer and posting on spouse ground. First of all, during the present pendency of the present proceedings, the petitioner was considered for his transfer and posting, and accordingly he has been transferred in the annual transfer ATC-2024. What do you call it? Annual transfer?
C4.
I forgot it. ATC 2024 to 51 Battalion SSB, which is situated at
Sitamari.
Sitamari, Bihar. Also, the grievance of the, which again happens to be anomalies. Grievance of the, accordingly, it is seen that the grievance of the petitioner in the present proceedings has been redressed by the respondent authorities, and accordingly, no further live issue for adjudication would arise in the present proceedings. Full stop. Accordingly, the writ petition stands dismissed as having become infructuous. Not happy?
Okay.
After a point, don't elongate a case. It might even go against you. You have got your relief.